Test. Like, might as well put it on top of it. No, next time we get a small podium, you know, those tabletop. Test. Is this good? This good, Janie? Is this good? Okay.
Yeah, I mentioned that to Mike as well, but it says that it's not affiliated with the government, but I didn't notice from the spelling. So thank you for pointing that out.
Ms. Grant, are we good to go? Not yet? Oh. Okay. Sorry. And anyone who's planning this evening to give testimony, if you would please sign in. Believe we're ready? We're good. Oh. Good evening, everyone. I'd like to call to order the meeting of the Village of Biscayne Park Code Compliance Board. It's Wednesday, March 20th, and the time is 6:05. Would the clerk please call the roll?
Jenny Anderson.
Here.
Dale Bennington.
Here.
Adolfo Barrientos. Judy Himmelberg. Michael Lanat.
Here.
Again, good evening, everyone. This is a meeting of the Village of Biscayne Park Code Compliance Board. All right, we'll go over you. The board is authorized pursuant to Chapter 14 of the Village's Land Development Code to ensure compliance with the village's code of ordinances. Okay, I'm going to start again. Okay. Oh, one more time. Thank you all for your patience, first of all. Good evening. This is a meeting of the Village of Biscayne Park Code Compliance Board. The board is authorized pursuant to Chapter 14 of the Village's Land Development Code to ensure compliance with the village's code of ordinances. The members of the board are citizens and residents of our village. We volunteer our time and we are not paid for our services. The purpose of each hearing is to give any alleged violators the opportunity to contest the decision of the Code Compliance Office, which results resulted in the issuance of a notice of violation, and to determine whether a violation of the village's code has occurred or is occurring. We are not authorized to dismiss violations based on hardships, ignorance, or the fact that others might be guilty of the same violation. These hearings are conducted in a quasi-judicial manner. Our responsibility is to act much like a judge in a court, and that is to hear cases presented by the village's code compliance officers and to hear contradictory arguments presented by the alleged violators. We are not authorized to change the code. The village commission is solely authorized to enact or revise codes. Conversely, neither the commission nor the village manager have the authority to overrule the findings of the board. Pursuant to Chapter 162 of Florida statutes, orders of the board can only be appealed to the Circuit Court of Miami-Dade County. We have the authority to assess and order payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code compliance officer's decision, we must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. All documentary evidence presented by the parties must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code compliance officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witnesses regardless of which party first called them, and to testify and rebut the evidence against them. If you intend to address the board this evening and you haven't signed in, please do so. Anyone wishing to address the board, please stand and raise your right hand so that you may be sworn in. You are reminded that this board is a quasi-judicial board. Giving false testimony can be penalized. Clerk will please swear everyone in.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Do we have any additions, deletions, or changes to the agenda?
I'd like to make a suggestion that we move item 8, 12, 13, and 14, the officers and present up be heard.
I would second that motion. All in favor?
Aye.
Aye.
Motion passes. All right, we will go straight, if everyone's prepared, to 8, 12, 13, and 14.
That was Dale Janey. The motion.
Yes.
And I second. On Tuesday, March 19th, Attorney Sean Widner filed notice of his appearance informing the village that he will be representing the property owner in these matters involving 111615 Griffin Boulevard. Mr. Widner's notice failed to timely inform the village of his appearance in this matter, and by operation of the above referenced ordinance, I will read the ordinance in one moment, this matter has been automatically continued to the next regularly scheduled board meeting. However, if a supermajority of the board decides to hear this matter tonight, the matter may move forward as scheduled. The ordinance reads, per chapter 14.1.6 of the Village Codes of Ordinances, if a violator or the owner of property that is subject to an enforcement proceeding is represented by counsel, the violator and or property owner shall notify the village in writing of such representation no less than 72 hours prior to the hearing on the violation before the Code Compliance Board. If the violator or property owner fails to give the required notice, the hearing on the alleged violation shall automatically be continued to the next code board hearing unless by a supermajority vote, the code board members present the code board elects to hear the case. Does any code board member care to bring anything forward with regard to this matter?
I think in light of the fact that we have 3 police officers that are here and costing the village to be here, taking their time out, that we should consider hearing this.
Doreen, could you tell me, was the attorney notified of our ordinance and when was he notified?
He was notified today.
I'm sorry.
He was notified today. We received a notice of appearance yesterday, and we notified him today after council advised us to make sure he knew about the ordinance.
But did he know in advance, 72 hours in advance?
So what the ordinance requires is for him to notify us 72 hours in advance.
Just wanted to be clear on that because I have to say, I totally agree with Judy. We have 3 officers here. They are on their time. Village is paying for this. This is would be the second continuance.
That's correct.
We were asked in February to continue this case, and we did. I have a real issue with the second continuance when we clearly have the ordinance on our,
Was an attorney filed an appearance the first time they asked for continuance?
No, they didn't have an attorney at the time. He filed notice yesterday.
Okay. All right. Okay, so the attorney is here. Okay. So I didn't know, I had an issue with due process, rights versus timeframes like 72 hours, but the attorney is here, so.
I would like to bring to the attention of the board that village attorney, Brad Wiseman is on Zoom. And if you need clarification on this ordinance, he can clarify it for us.
But no, I understood the ordinance.
Michael, I don't think the attorney for the resident is here, the property owner.
Is here.
Yeah, he's
Is
here.
Oh, okay.
I didn't know if you wanted me to come up right away or.
No,
so
my misunderstanding.
Yes, okay. Was there like a motion or somebody making a motion?
We'll call the roll. Or will you do the motion first and then we'll call the roll?
Chair.
I'll make a motion. I don't know what's going on. I'll make a motion that we go ahead with the hearing this infraction as we had planned.
I'll second the motion. I would have been probably grant the continuance if the attorney wasn't here, again, on due process rights over, timeframes of 72 hours or less. But the fact that the attorney is here and ostensibly ready to argue this, and we've got the village attorney, I'll second the motion.
Mike,
would the clerk please call the roll? We need a voice vote.
Jenny Anderson,
Yes.
Dale Blanton,
Yes.
Rodolfo Barrento,
Yes.
Judy Hammerberg,
Yes.
Michael Leonard,
Yes.
Passes 5-0.
Doreen Grant, Code Compliance Department for the Village of Biscayne Park. The first item is on section 8 of the agenda. It's 8.12. And this is for case number CEN 246 for the property located at 11615 Griffin Boulevard for Maximia Holdings LLC. We have opposing counsel present, village counsel present via Zoom for the board, and 3 witnesses from the village police department.
Shall we take the officer's testimony first? Or does anyone on the code, any of the code staff have anything to fill in?
Okay, I'll fill in. This particular case was for offensive noise prohibited noise, they were in violation of section 10.1 and necessary and excessive noise. This violation was issued in the first offense and it comes with $1,000 fine. This particular property is a short-term vacation rental and hence the excessive fines that were assessed for this violation.
Anyone on the board have questions? Then if we would, I would like to take the police officer testimony first.
I think the council should go first. The council can go first in defense and then the police officers can give testimony.
Well, need the officer's testimony.
Testimony.
to First, yeah, thank you.
So the first case, look in the file, let's give him the, yeah, first.
January 18th.
It's the one issued January 18, that's you. Thank you.
Right. Start right, okay,
If
good
you would,
evening,
sir, introduce yourself.
yeah, absolutely. I'm Corporal Rogers with the Village of Biscayne Park Police Department. We want to just get right into it. On January 18th, 2024, around 5 in the morning, we were dispatched to 11615 Griffin Boulevard due to a complaint of loud music. I believe I was here at the police station when the call went out. If anybody knows the area, 11615 Griffin Boulevard is literally right around the corner from the police station. Takes less than a minute or so to get there. When I arrived, there was no loud music playing that I could hear as I was approaching the residence. But as I entered the front yard of the residence, I was able to hear loud noises, loud speaking, like a party going on inside of the residence. I knocked several times on the door. Finally got some individuals to come out who were renting the place. As it was already stated, that place is a Airbnb short-term vacation rental. I asked to speak to a responsible party. A young man came to the door. I believe his name was Mr. Williams. 1999 was his birth year. He came to with a Washington DC driver's license. I explained to them our ordinances of the Village of Biscayne Park as well as Miami-Dade County. And it was also known to me that I had just found out rather that officers had responded to the address earlier in the night for a very similar call. They didn't issue any citations, but did use their discretion to issue a warning to those individuals at that time. Because it was our second time responding, because there was loud noise at 5 in the morning that I was able to hear from the exterior of the residence, I chose to issue a Miami-Dade County civil citation at that time. And that's pretty much it.
Any questions for the officer?
I would like to enter into evidence, police report number BP 240-118-0000061. I would like to enter into evidence as well, a ticket issued to the individual at the property V038052.
So I got some questions, Corporal, and thank you for your service.
Yes, sir.
But being that this is a quasi judicial board, we've got to, ask some questions.
Absolutely.
And my understanding from your testimony and also from looking at your police report is that your call that you received was for a disturbance in the form of loud music.
Correct.
And then you were over here at, what is this, 114th?
114th and Northeast 6?
114th. So you're basically 2 blocks away?
Not even.
Not even. And so did you go there by your car?
Yes.
So you went by your car. I mean, what would you estimate that it took you from the time that you got the call to the time that you arrived at the residence?
Like I said, maybe a minute or so. No
Okay.
more than 2 minutes to get in the car and to get over there, but within
Okay.
1 or 2 minutes.
And how was it that you were dispatched? Like what information did you receive?
So as my report states, we received a call. It was a disturbance. Obviously, we use code, so they gave the code over the radio. It wasn't emergency mode or anything like that. It was a routine call, as we would say it, for disturbance regarding loud music.
I mean, like, the person that was, reporting the call for loud disturbance, was that guy on the phone, or was it you dispatched?
No,
from
we get dispatched by Miami-Dade County dispatchers.
Okay,
Right,
so I
they-
appreciate that.
No, absolutely. They received the calls. And as I also stated in the report, the complainant did not want to give their information, which is 100% allowable and understood. They called in anonymously to report the disturbance at that location. And then we were dispatched by Miami-Dade County Dispatch to that location.
So basically, I just want to understand it. So basically, you got dispatched, you're sitting at the office, you get in your car, you're there within a minute or so, and the report of loud music was not confirmed. It was just, there was no loud music. Is that fair to say?
I did not hear any loud music.
Okay, and then when you approached the door and you knocked on the door, was it from there that you could hear loud noises emanating from there that were not in the form of loud music?
No, so as I stated before, as I entered the property
Okay,
from the street, you could already hear loud talking, screaming from inside, not screaming like in fear, but people like a party. That is what I described it as back then in January. It sounded like they were having a party inside of the residence at 5 a.m.
but at this point, there was no music that you heard?
I did not hear any loud music.
Okay.
Yes, sir.
And then the information that you had testified to with regard to another officer had indicated that there was a call earlier that night to that
Correct.
same address?
Yes,
Was that before you got on shift?
it was.
Okay, so, was your shift and the other officer's shift overlapping at this point?
So my shift normally starts at 7 a.m. For some reason, we needed some extra coverage and I came in early. Forgive me, I don't remember if my shift started at, the time 3 a.m. kind of sounds familiar, but I don't know if I started at 3 or if I had started right at 5 and then that call came out. And the other officer who was on shift, he's also here and involved in a previous case, so maybe he can speak to that as well.
Okay. What was that officer's name?
Officer Sanchez,
Sanchez.
Corporal Sanchez, I'm sorry. He's present. He was on the night shift that evening, so he would have been the one that responded earlier. I think I even wrote the time down. On the 17th, which was obviously the night before, but at 11:44 p.m. And then I responded at 5:01 a.m. on the 18th.
And was that 117, which was the same night? It was just
One-
earlier. It
Yes.
hadn't gone past 12.
So
And-
about,
And was that music or just loud noises that he had heard? And maybe he could speak to that, but
he can speak to that. I didn't notify.
you just know that there was a call out to that property because something was going on
It was
and
another disturbance call. I do know it was a disturbance. Not 100% sure if it was due to loud music or some other type of disturbance at that location.
What I'd like to point out is if you look at the notice of violation, the violation of code section 10-1, offensive noise prohibited. It shall be unlawful for any person to make, continue, or cause to be made any continued loud, excessive, unnecessary, or unusual noise. It is not
Only loud
constrained
music.
only to music.
Yes,
And the charge on the report is unnecessary and excessive noise. So
Correct,
it's
and that-
not strictly a music issue.
right. And to that point, that's how it's actually listed on
That's how the
the
code
Miami-Dade
reads,
and on the
exactly.
Miami-Dade County
Miami does
civil
spell out.
citation, which is what was issued. It's for excessive noise, not necessarily
Right,
excessive
doesn't have to be
music or
music.
anything like that. Yes.
Anything?
No, Michael's done a great job of asking questions. I've made notes. I'd already had a few circled things.
yeah, so
Thank you.
yeah, what I'm struggling with is that you're so close and the issue came in as a disturbance for loud music. And you went there and then you didn't hear loud music. And it was as you approached the property that you heard what you categorize as loud noises. So, I'm just trying to struggle with, what the reason why you were going out there. And then when you got out there, it actually wasn't confirmed. But as you approach, you hear some things on the outside that are loud noises.
Right.
And from your vantage point, I mean, I don't know how you can best articulate it, but in terms of what those loud noises were, like, how would you characterize what you heard as you approached there? You talked about the voices and all that stuff. I mean, is there a decibel level? I mean, like, what was it like? Like, if you were, outside, walking your dog in the morning, would it be something that would be disturbing, or would you think that, hey, somebody's, having a good time in there? I mean, how would you characterize it?
Sure. So the way I look at it is, number one is I'm not the complainant, right? I'm the responding officer. So the complainant is a resident, more than likely, who lives either right next door to, because there's houses on either side of that location, and there's also residences across the street from that location. It could have been any one of those residents at 5 a.m. that felt it necessary to pick up their phone at 5 a.m. to call the police because there's some sort of disturbance that they believe is happening at that location. I do think that it warranted a citation. For one, it's 5 o'clock in the morning. I know I don't like to be disturbed at 5 a.m. in the morning with loud talking, loud music, screaming, yelling, parties. Those are not normal hours for things like, if it was 5 in the afternoon, maybe not, but 5 in the morning. And like I said, the noise that I heard was audible from, and I won't speculate about a decibel level. I wasn't measuring decibels or anything like that. But I was able to hear loud talking, loud voices from the exterior of that residence. If we step outside right now, I can guarantee you, we probably won't be able to hear the conversations that's happening in these residences right around us. I was able to hear those conversations from outside of the residence. And it makes me believe that that anonymous complainant was also able to hear that stuff. And maybe they also heard individuals in the back of the residence where the pool is and things like that. And those sometimes also prompt phone calls from our citizens for us to respond to those types of disturbances.
So let me ask you a question. So if you hadn't received this information from Corporal Sanchez with regard to what happened earlier that night, would that still from the loud, because it's fair to say that you didn't confirm what your reason was that you went out there, right? You went out there for loud music, but you didn't hear loud music. You heard what you considered to be, some loud noises. If you hadn't received that information from Corporal Sanchez, would you have been issuing a warning like perhaps he did earlier that night? In other words, did Corporal Sanchez's information that he provided to you cause or contribute to your decision to give this violation?
I would say that it's a contributing factor, but it wasn't the sole factor that I based my discretion on. Once again, I observed, I'm my own person. I responded to that location. I was able to hear the noises. I'm considering the time that call is coming in. And the fact that you have a resident that doesn't even want to be contacted for whatever reason. And I don't want to get into some of the other times that we've had to respond to that because we're speaking specifically to this particular case or this instance. But like I said, his responding earlier that night with the same group of individuals that were there, it's not like it's a different set of people. These are the same people that were already contacted by police, already warned, already made aware of the community that they're visiting. Because the misconception a lot of time is when these people from out of town, as I told you, this guy's from Washington, D.C., when they book these short-term vacation rentals, they think they're coming to Miami to party and things like that. And I explain to them all the time that, yes, you're in Miami, but you're in a little subdivision called Biscayne Park. And this is a quiet town. They respect their peace, and they expect for anybody that's visiting here to also conform to those things.
I'd like to ask a question.
Yes, sir.
Need to move on.
Yeah,
Absolutely.
but no, this is just to clarify.
Sure.
The home that you're speaking of has a property next to it, a residence, a property on either side, as well as properties behind it. So it's not an isolated home with no property behind it. There
Correct.
is a pool there.
Yes.
As well as a yard. So anyone out there early in the morning speaking or carrying, having a little party, it's rather audible throughout. So you don't necessarily have to hear it from the front. And I believe at least one or two of the homes are offset, located somewhat behind. At least one of the homes is located behind the current house that's set up front. So anybody out in the back or with doors open or property open would be maybe more disturbed than anybody from the street.
Correct.
Thank you.
We live in a small community. We have a noise ordinance that goes into effect at 11 p.m. and people expect to have the quiet for their sleep hours. And You know, I can't tell you, I've never called the police on. The last one I did was a city of North Miami party 10 blocks away or 20 blocks away that we heard. But I think people have the right to their rest and I think that even though there are Airbnbs and we can't stop them, we still have every right to enforce our laws for the residents and for the visitors here.
Rodolfo.
No, she said it all.
Thank you, officer.
Thank you.
Do you want me to like kind of sit over here so I have a microphone? Was that? that'd be easier?
There's, well,
Okay, right here?
right
Okay.
there's, fine.
Um,
If you would identify yourself,
Thank
your
you.
relationship to the property.
sure. Sean Widener, I, on behalf of the property owner, represent the property owner. Corporal Rogers,
Excuse me, sir. Can you speak to the microphone, please?
sorry, how's this? Better?
Lift it up.
Lift it up. Here we go. How are we doing? Good?
Better.
All right. Good evening, Corporal Rogers. I just want to ask, when you went to the property at that morning at 5 a.m., where did you park your vehicle? Was it on the street or in the driveway? Okay, so on the street. When you exited your vehicle on the street, did you hear any noise coming from the residence? Okay, so I was trying to get like about how far up into the yard, how far would you say you were from
Sir,
the
I
door?
apologize. I need to interrupt you a second. Corporal, if you would please stand at the mic also, because we won't have you on audio without that. Sorry for the interruption.
About how far would you say you were from the door of the residence when you started to hear the noise?
Well, I'd like him also to be on camera.
Oh, I see.
So, as I stated, as I entered the property, as I entered the yard, I was able to hear the loud noises and the loud talking.
Okay. And. Sorry. How's it? Ooh, here we go. How's this? All right.
Improvising.
The first time I ever cross-examined one like this.
Need longer cords.
Let's see. And Corporal, did you take any videos or audio recordings of the disturbance?
No, I did not.
Did you use any recording devices like a decimal?
No, I did not.
Do you know approximately how many feet away from the residence, the doorway you were when you finally started to hear some of the sound?
Whatever that distance is from the front door to the edge of the driveway.
Okay. You said Corporal Sanchez was out there that same night. Have you had any other calls to this residence?
I have.
How many would you say?
I wasn't prepared to answer that question, but I've been there on several occasions. I don't have, I mean, I was just there Saturday morning as well. So we've been there quite a bit.
Okay. Is this like a regular occurrence? this residence?
It seems to start becoming a regular occurrence. It's almost as if that residence is like a party house. I don't know if it's intended to be that way, but it kind of seems to be that way.
So would you say on maybe on a weekly basis, how often would you get a?
It's hard. You can't, it's not.
Officer, if you
yeah.
don't have exact figures, do not feel compelled.
No, I understand. And that's what I'm about to say. It's not a weekly thing. These calls are random. And it also depends on who's renting the house, when they're renting the house. I'm sure sometimes there's families that rent that house and we don't get a call at all. Sometimes weeks go by and we don't get a call, but then sometimes there's times where we get several calls back to back from that location, but I don't have exact numbers in front of me.
Okay. And how many citations have you issued? Is this the only citation that you've issued?
Yes, that's the only citation I've issued at that location.
Thank you, Corporal. I have no further questions.
Thank you.
We have any further input from the code staff? Any further input from the board? I need to sort of, because we do have the two more coming behind this.
Yes. We want to do testimony for all three and then just.
Well, we do one at a time, sir.
Okay.
Yeah.
I just wanted to have, I have some handouts. I'm sorry, can I ask Corporal Rogers one more question, just for the. Do you recognize?
Sir, sir.
Sorry.
Microphone.
Microphone. Do you recognize this picture, the house in this picture?
Yes, in the picture has looks like a red type roof with the squared off driveway there.
And that's the subject property?
Yes, yes.
Thank you, yes. Good evening, council. Thank you very much for having us tonight. Council, I just want to point out to the first,
Microphone, please.
sorry, the first image that Corporal Rogers pointed out as the subject property with the red roof. This is an image taken from Google Earth with measurements where you can plainly see the first dot showing the starting point of a measurement. The second one is at the edge of the driveway, at the edge of the roadway nearest the house, and that is measured at 60 feet. And you could see where the dotted line goes across to 100 feet, and 100 feet away from the front of the house is basically the property line of the property across the street. The second image is a little better zoomed in diagram of the measurements. So I'd just like to point out that Corporal Rogers stated he heard nothing when he got out of his car, got his vehicle, when he was on the streets. He didn't started to hear noises until he got within the yard, within the residence, and this was at 5 a.m. And the noise ordinance, as you all know, states that it's a prima facie evidence of a violation within 100 feet during the time frame of 11 p.m. to 7 a.m. In this case, Corporal testified that he heard no noise until afterwards. It just goes to show that he also testified that he was there within a minute or two of the complaint being called in. So it's not like something where they had time to shut down a party or anything. This is noise, as he testified, that we're just coming from inside the house. As he said, and as someone may point out, it may be a little louder to the neighboring properties who are directly behind it. However, the fact is that the residents here and their tenants also have the right to use and enjoy the property. There was no loud raucous party. There may have been something slightly louder than a normal conversation, but going on in this house, it wasn't a super loud party. He testified straight up that he heard nothing at the driveway, at the roadway. Therefore, for this violation, we would ask that the violation be dismissed as there's no finding of an ordinance violation.
Okay, my issue is 100 feet in which direction? Because the property to the property lines are usually 10 feet. And there's a home that's really nearby. So the homes adjoining it may very well be hearing it. Just because you don't hear it from the street does not mean you can't hear it from the adjoining properties or from the properties behind. So I don't agree with your statement that if you can't hear it from the street, you can't hear it from anywhere within 100 feet.
I would agree with your statement, and I would say that there is no testimony put forward this board to show that any noise was heard from any other property. So there's no evidence that would be completely speculation. If there was a property owner, an adjoining property owner who was being disturbed, they certainly have not shown up to testify to that. So I would submit that there has been no evidence shown as to this violation.
I would like to hear from Corporal Sanchez if he was, if he had gone by earlier and just given a verbal warning on the same evening. Or with the same residence, at the same residence with the same, people at, I believe, 1144.
Corporal Sanchez with Biscayne Park. I cannot test to the previous call because I didn't come here for that case, which was the previous case.
It was a warning.
Have recollection of having.
No recollection of that night.
And you wouldn't have created any type of a,
There is case log entry generated, but as much as that, I don't recollect what occurred that.
so would it be fair to say that, based on your lack of recollection, that, the lack of preparing a report, or if you had issued something formal, that there'd be a written evidence of it, in the absence of that, that you can't provide any information about what occurred that night on the 17th at 1144?
Correct. Like I stated, since I came here, it was not pertaining to Corporal Rogers' case. I'm here on a totally different one. But I can attest that if I did respond to that and I did not hear any music or anything like that, there was no citation issued or any report written. So it is the possibility that once I did respond, there was nothing heard, but we still might have, if I'm not mistaken, we still might have spoken to the actual occupants and have explained to them both village and both county noise ordinance reference the unnecessary and excessive noise ordinance.
Thank you,
Yeah,
Corporal.
no problem.
Any other comments?
No.
I'm ready for a motion.
Yeah, I'll make a motion to dismiss the infraction. I base it on the fact that I take both Corporal Rogers and Corporal Sanchez at their word in terms of what it is that they heard or didn't hear when they arrived at the property. There was a noise complaint that was, at least according to Corporal Rogers, investigated by Corporal Sanchez at some point earlier that night, that apparently didn't rise to the level of Corporal Sanchez at 1144 on January 17th of 2024, issuing any type of a formal warning. There was a second call, evidently around 5 in the morning, that Corporal Rogers received, and was only within less than 2 blocks, and took him about a minute to get there. And when he arrived, the information that was provided on the dispatch was not corroborated, insofar as he did not hear loud music. He didn't hear loud music when he exited his car on the street, and he walked and did not hear it until he walked within the property.
We have a second.
I'll second the motion.
We have a motion on the floor. First and a second. All in favor?
Aye.
Aye.
All opposed, say no.
No.
No. Rodolfo.
Fine. No, sorry.
Motion fails 2-3. I'd like to make a motion in light of the testimony that we heard and the very obvious that properties in the back and on the side could very well have detrimentally been affected by this noise, and doesn't necessarily mean it's going to be heard in the front. I would like to affirm that a violation has occurred and that in CEN 24-6 and the violation fee of $1,000 be upheld.
I'll second that.
All in favor, say aye.
Aye.
Aye. Opposed, say no.
No.
Motion passes 3-2.
The second case is in section 8 of the agenda. It's item number 8.13. It's for the address 11615 Griffin Boulevard, and it's for the case number CEN 24-64 for Maxmia Holdings LLC. This is another violation for offensive noise. It was unnecessary and excessive noise. In the second offense comes with a fine of $2,000 for this short-term rental, and we have a police officer as a witness.
Any questions from the board, or should we? Which officer will be testifying to this one?
The date,
February 1st?
January. February 1st. Apologize for that.
Hello, good afternoon, Officer Rosero. I've been with Biscayne Park PD for 5 years now.
Welcome, officer.
Congratulations.
Thank you, sir. In regards to this incident, this occurred on Thursday, February 1st. We were dispatched to 11615 Griffin Boulevard at approximately 8:11 p.m. and in reference to a loud noise disturbance. Upon arrival, typically when I respond to any of these kinds of calls, I like to park my vehicle across the street or in the median from where the home is located. And will actually, is the way I operate. I sit in there to see if the noise can be heard at that distance. I've responded a number of times to this property, different times, day and night, over the course of the past few months. And basically, when I was in the car, the moment I opened the door of my vehicle, I could hear already the noise coming from the house, emanating from inside the residence. I exited the vehicle and walked over the street. I went over to the south gate and I attempted to get the attention of whoever was in the backyard. I screamed, flashed. I have a pretty bright light that I put in the back, and I did not get attention for a few minutes. And after maybe a minute or two, somebody came in the front of the house and made contact. There was a young man. He told me that he was renting the house for a vacation with a group of friends. And he was, polite, apologized for what happened. And I basically explained what was going on. It was, it was still 8 o'clock, but I responded there a number of times as a primary and a secondary officer. I have never issued a citation for that particular location, but this time I definitely feel that the noise was excessive. And I proceeded to go ahead and write a citation for the incident.
And what was the type of noise that you heard? Was it music?
It was loud music, like a party was happening in the back. People was screaming and different voices. Probably I could hear 4 or 5 different male voices. You could hear loud splashes on the pool, and there was a lot going on. And to prove my point again, when I walked to the fence, scream, police, police, please come outside, and nobody responded. So somebody showed up in front of the residence.
At the gate or at the gate? Or at the door?
At the front door of the house.
Thank you, officer. Any questions from the board? Mr. Attorney, if you would.
Yes, thank you.
Thank you, sir.
No problem.
Good evening, Officer Romero.
Rosero.
Rosero, sorry.
No problem.
I just want to show you with this exhibit. Does this look like the subject property with the red roof, red orange roof?
The red, yes. That's the
Okay.
one. Mhm.
Where did you say you parked your vehicle, either in the street or median? Could you kind of?
Approximately around here.
Okay, so in the median between the two opposite roadways.
Yes, sir. That's correct.
Could you please speak in the microphone? We won't be able to hear that.
Sorry.
Okay, and you said as soon as you opened the car door, you could hear the music?
Yes, sir.
Party?
That is correct.
You also said you responded several times at this property? Can
Yes,
you
no, I'm
say
sorry.
approximately how many? Would it be more than 10, more than 20?
I'm sorry, I wouldn't. It will be irresponsible for my part to give you a number because I really don't remember right now.
Okay.
But I've been there a number of times because I even know the address already, so, but never issue a citation in the past.
Okay, and why is that?
We have responded, came in, like I said, I've done the same thing where I parked across the street and similar to the situation with the officers, I could not hear the noise until I was inside of the property in the front yard. And we still make contact because we have received the disturbance calls. We want to make sure that everyone is safe inside the house. And everybody came outside. We have taken it as a try to educate people that are staying in the home. But no, if we didn't find anything that will be disturbing the peace of the homes around that residence, then we will not issue. We just go ahead and give them a verbal warning to them.
Okay, and on this evening, when you issued the citation, did you take any audio or video recordings?
No, sir, did not.
Did you use any sound measuring devices?
No, sir, I did not.
Thank you. No further questions, officer.
No problem. Thank you.
Real quick, officer.
Yes, sir.
Is it corporal? Corporal, right?
No, officer.
Officer.
Yes, sir.
The call was anonymous that came in, or do we? know?
Yes, sir.
Okay.
Yeah, it was an anonymous call.
So we don't know if it's the same person that called in the earlier call in the 18th or not?
No, it was most of the times that I've responded there, it has been an anonymous call.
Is that typical that you usually get anonymous, or is?
Yes, sir. Is a common practice. I guess it will be from, neighbors don't want to have disputes with the next door neighbors
Right.
or whoever is behind the residence. So typically, to give you a percentage, probably 80% of the calls that we get are usually anonymous calls.
Okay, thank you.
No problem.
Any other, any comments or questions from the board, from the code staff?
I would like to enter into the record police report number BP 240-201-000-102. And I would also like to enter onto the record Miami-Dade County Civil Violation Notice number V037552.
No questions. I'd like to make a motion.
Please.
I'd like to make a motion in case number CEN-24-64 that violation had occurred and to affirm the fine of $2,000.
I'll second. All in favor, please say aye.
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 Any opposed, please say no. Motion passes 5-0.
The next case in section 8 of the agenda, it's item number 814 for the address 11615 Griffin Boulevard. It's case number CEN 24-65 for Maximia Holdings LLC. They were found to be in violation of section 10-1, offensive noise prohibited. It was unnecessary and excessive noise. In the third offense, this comes with a violation fine of $5,000 for this short-term rental. We have a police officer as a witness to this violation.
Doreen, could I ask a question before he testifies? Okay, the question I have is that this obviously is a registered short-term rental with Biscayne Park.
That's correct. It's licensed.
And these particular, ordinances and so forth, they're communicated in that when the license is issued? I mean, they know that they got to abide by the rules that a regular resident would?
Before we issue these licenses, we do an inspection, a walkthrough with the property owners or management company. We require them to put notices across the property, inside the property, with the ordinances like the noise ordinance, the trash ordinance, and they have to abide by those codes. We ensure that they explain to their tenants at each of their rental time that they are aware of the noise ordinance for the village and the other ordinances as well.
Okay, thank you.
Yeah.
If you would.
Corporal Sanchez with Biscayne Park. I am one of the two supervised night shift supervisors on Friday, February 9th, 2024 at 0:30 hours. Units were dispatched to 11615 Griffin Boulevard in reference to a large gathering in the backyard. Upon arrival, music and loud talking were heard from the front of the residence. We spoke with the renter at that time, was Mr. Tyler D. Radel, and other occupants, and we spoke to them about the Miami-Dade County ordinance, and they were issued a civil citation.
Questions or comments from board?
So what was occurring that created the civil citation?
What's that, sir?
What was it that you heard when you arrived?
Loud talking and loud music.
In terms of the number of folks that were there, did you get an idea of how many people were there? Because
Yes, it was approximately 5 to 6 males.
The 5 to 6 males gathering in a house is considered a large gathering?
Well, we were dispatched to a large gathering.
But when you got
But when
there-
I got there, we heard loud music and talking. Large gathering can be could be multiple. It could be 5, 6, 7, it could be 2, 3, 4 people.
So the anonymous call said there's a large gathering at this particular residence?
Correct.
Okay, and when you got there, there was, would you say 6 males?
Yes, sir.
No females?
Not that I saw.
Okay. How big is this property?
I do not know, sir.
Of
I
course,
believe it has a capacity of 10 to 12 occupants.
Okay, this lot size is 20,000 square feet and the house is what, 2,200 square feet?
It's a very large property.
And, okay. And Tyler Radell was one of the 6 males?
Correct, sir. He was the, when I requested the responsible party who was the renter, he was the one that said that it was him.
And you said you heard loud music and what else? And you heard
And talking, sir.
loud talking. You didn't hear splashing or screaming or anything like that?
No, sir.
of course, you can have loud talking and loud music and have 2 people.
Correct.
So it's not necessarily dependent upon the size. Rodolfo, anything? Anything more the board would, I'm sorry, the code staff would like to add? Mr. Attorney, sir?
Thank you. Good evening, Corporal.
Good evening, sir.
Corporal, when you arrived to the house, did you arrive by vehicle?
Yes, sir.
And where did you park your vehicle?
In the median, sir.
When you got out of your vehicle, were you able to hear any loud noise or any noises?
Yes, sir. I was able to hear it from the median.
And how loud was it from the median?
It was loud enough that I was able to hear it from the median.
Or was it like disturbingly loud, or was it like a faint, like, maybe off in the distance?
Well, I can't define if it's disturbingly loud because I am not the complainant. I'm just the responding officer.
Okay,
But if I could hear it from the median, which is obviously, I think you pinpointed that it was 60-something feet from the front of the house to the driveway, and this is obviously occurring in the backyard. So it's obviously more than 60-something feet. So we're talking about what, about 100 feet maybe?
correct.
Okay, so I will consider that disturbing.
Okay, was it, so you consider it disturbing?
I would consider it disturbing.
Is that why you issued a citation?
No, sir. I issued the citation because it is a violation of the city and the county ordinance.
You have to find it also.
Correct. I have to be able to hear it. And I heard it.
Okay. From your vehicle, I'm just trying to get like, was it as loud as if you stood, make like heavy traffic?
Well, okay, sir. I don't know if you're familiar with Biscayne Park. At midnight, you could hear anything. There's no noise, there's no traffic, there's nobody walking. So anything here travels. So if I was able to hear, you can hear it from the median.
But that's what I'm trying to say. Can you hear, like, you can hear from somebody, sometimes you walk by a house from the driveway, you can hear someone playing loud music inside, but from the outside, it's kind of muffled. That's what I'm trying to get is like, how loud was it?
Well, I didn't have a measuring, we don't use measuring decibel measures or anything like that, if that's what you're trying to get to.
Okay, so it's all subjective, purely based on your opinion?
Yes, sir.
Okay, thank you. No further questions.
If there are no more comments, questions, or input from the code staff,
No questions.
I'm ready for a motion.
Sure.
I'd like to make a motion in case number CEN-24-65 that a violation did occur and to affirm the $5,000 fine.
I'll second. All in favor, please say aye.
Aye.
Aye. Any opposed?
Aye.
So that would actually be no.
No.
Okay, so motion passes 4-1. Thank you, officers, very much. I much appreciate, Mr. Attorney.
Thank you.
Thank you, sir, for coming in.
Bye-bye.
Okay, you have to back up a little. There are a couple things at the front of the agenda we didn't get to.
We'll move on to section 7. We'll move back to section 7 of the agenda.
Go to minutes.
Oh, go ahead, please.
On those until after, at the end. So if there's any corrections, I would prefer, because I don't want to waste people's time while we discuss technicalities.
Minutes to the end.
I just
We're
want to
good.
say thank you all very much for having me.
Thank you, sir.
Okay, thank you for coming.
Just one little kind of point of order, if nobody minds. When I call for the vote, we're used to always saying aye or yes if we're in favor. But when you're against, I know it kind of goes against it to say no, because you're actually saying you are against, but if you say yes, when you're against something, it kind of gets conflicted with the actual yeses. So anyone who's against and voting no, please say no or nay. Move the minutes. Next case.
While we have the village attorney on Zoom, I'll call cases. Where is this lady?
Dorian?
In section 7, this is items 7.7, 7.8, and 7.9. Are you here for those cases?
No, I was just actually going to ask if it's okay, just because she has kids, if those of us that are okay with it, to maybe let her case, I'm not with her case, but let her
Ali?
case be called first, just so that she can get
The
kids fed and to bed, unless anybody else from an order has an objection to that. If that would be okay. Sorry, I don't mean to
okay.
hijack, but I have little kids too. So.
This one's gonna go quick. We are just calling. Okay.
Okay, I'm sorry, let's back that up again. It's 7.
It's 3 items in section 7, and it's items 7.7, 7.8, and 7.9. These are for the property located at 11724 Northeast 6th Avenue. The first case number is EEN 21-0227. Next case number is EEN 21-0229. And the next case number is EEN 21-0250. These properties are owned by 11724 Northeast 6th Avenue LLC. We are asking for a dismissal of all these 3 cases, and the village attorney can explain.
Madam Chair, it's Brad Weissman, the village attorney, if I may.
Brad, if you would go ahead.
Sure. So as you can tell, these are relatively old violations that occurred back in 2021. What had happened is there were orders of enforcement that were entered with comply by dates. It appears that these, and Doreen can correct me if I'm wrong, but based on my memory, these are doing some construction work without permits. And one of them was dealing with an unpermitted dumpster. And essentially what had happened is the property owner or violator did not comply in time in accordance with the board's order. However, a a note of an affidavit of not compliance was never filed by the village. It was not until February of this year where an affidavit of non-compliance was filed by Ms. Grant. And essentially what happened is what Ms. Grant did is calculated, going back in history, to look at when the comply by date was, when the permits were actually issued, and calculated the fines during that time period of non-compliance. The attorney, Ms. Streitfeld, has made an objection on a due process claim, essentially alleging that due to the lapse in time that the village took to file its notice of non-compliance, or its affidavit of non-compliance, I'm sorry, and ultimately giving them a due process hearing, that they are unable to put forth a defense, just based on the time. Witnesses' memories have faded, records are no longer in existence, and their claim was that they had been speaking to members of the village about these violations and in the process of working out those violations. In my opinion, that due process violation, if it were to be reviewed by the circuit court, would ultimately reverse any finding of a violation by this court, or by this board, excuse me. So we would recommend that there be a dismissal of these three matters.
And was this the matter that we were arguing about and we wanted to get Mr. Weissman's, okay.
That's correct.
I believe so.
Yeah. Okay, thank you. And I don't disagree with you, Mr.
Thank you
Weissman.
very much. Appreciate your input. Okay, we need a motion. Unless anyone has anything to add, we need a motion.
I would like to enter onto the record the written statement from the attorney.
Okay, I'll make the motion on EEN 21-0227 and on EEN 21-0229 and on EEN, or do we need to do them one at a time?
No, let's do it.
Okay, 21-0250, that as by the recommendation of attorney, we dismiss these cases.
I'll second.
All in favor, please say aye.
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 Any opposed, say no. Motion passes 5-0.
Thank you, Brad.
Thank you. You all have a nice evening.
Good night.
Who did the second on?
Michael?
Michael.
I think Michael did.
Yeah, thanks.
That's done. You know, we want to go for the lady with the kid?
We
She is?
we just got a request for the young lady with the children.
And I don't know which cases.
Yes, we have actually, we have two requests in the same section, and it's in section 9.
I believe she is the fine reduction.
That's correct.
Ma'am, if you would. The fine reduction, bear with me a second. Let me get. Let you know. 9-1, thanks.
Section 9, case, the item is 9.1. The address is 1109 Northeast 118th Street, case number EEN 21-0987. This is for Michael and Callie Van. If the board recalls, this is the case that had 4 orders of enforcement. This couple has worked diligently to ensure that all the violations have been corrected. The violations have been corrected. On behalf of the village, I would like to make a recommendation. I know they've asked for an amount, but I'm making a recommendation for $250 for the reduction. This couple has gone through some personal issues that I would like the board to take into consideration. Michael lost his mother. He was ill. He had to be taken to the emergency room. And they have a lot of bills, financial issues at the moment. But if the board can take into consideration that they had heavy fines on this property, but have worked very diligently to ensure everything comes into compliance, and to consider reducing this fine to $250.
Yeah, if I may ask for clarification, there are two different violations that they're requesting, so you.
That's correct. In fact,
Each,
250 for both.
50 altogether.
That's correct. That's what my recommendation is.
My concern there, if nobody minds, I'll go ahead and opine for the moment. My concern there is we have two separate violations and they both ate up a significant amount of staff time. I would be comfortable with 250 each. I would not be comfortable with 250 for both. I think at some point, and yes, they have been through some serious situations, but you have to cover at least a portion of the kind of expenses the village has been through in the 2 years it took for compliance. But that's just me. Looking for input from everyone, please.
So you're Miss Van? Yes. And it was your husband's who lost his mom? I'm sorry for the loss. And you'd also indicated, I think in your fine reduction that there was was it your husband that was injured?
Yes.
And that was in 2022, and that has been the cause or part of the reason for the situation going on?
Yes.
And you'd asked for a fine reduction down to $100 for each, right?
Yes.
Okay. And the recommendation, so you're asking for $200, right?
Yes.
Okay. All right.
And my comment is this, it is a hardship issue as well as it is a homesteaded property. And the residents have been in communication and cooperating while it did take a while, and seems like they are attempting. I'm of the opinion that to go with the village's recommendation of the 250 for both. That would.
Judy?
I see it both ways. Again, it's a big cost to the community. But again, for a young family, I kind of like, it breaks my heart. But it's a $15,900 fine, so you can't write it off without doing something. Can we do a compromise in between the 500 and the 200 and do like a 350 compromise? Would that be acceptable?
I mean, the village recommendation is 250 based upon the hours of work that she had indicated was poured into this and speaking to Miss Van and her husband, Michael. And, we've got death certificate or the obituary of the family, her husband was severely injured. I mean, at the end of the day, we are neighbors, and this is, and we do know that there was, that there is, time that's been put into it, and our minimum, for any particular fine is 250. So that's the recommendation from the village. I mean, the family has, lives in one house, maybe there's a couple of violations, but the bottom line is that there was confusion over the original violation that resulted in Miss Van and her husband, Michael, believing that the violation was void. So that obviously took a while to get worked out. It got worked out. And, as neighbors,
With all due respect, I don't think you were on the board during most of that time, and it did take 2 years, which I'm divorcing myself of that at the moment because of what they've been through, but in fact, it did take 2 years. I like the compromise of 350. I think that covers, as well as we can hope under the circumstances, the village's expenses in this going on for 2 years. I feel like 350 is a very fair compromise.
Well, it's not a motion, it's a fine reduction, and we would have to offer,
Oh,
we either accept or deny.
So we do need a motion as to whether accept or deny the 100 that Ms. Van is offering.
Not unless the resident wants to amend her
I'll accept the 350.
Thank you, Ms. Van. And
Do we need to do a vote on that?
Yes.
we need to make a motion.
I'd
Okay.
like to make a motion on case number EEN 21-0987 to accept the residents, property owners fine reduction of $300.
350.
Oh, 350. Thank you. 350 to be paid within 60 days.
I'll second that.
All in favor, please say aye.
Aye.
I
Any
agree.
opposed, say no. Motion passes 5-0. Ms. Van, thank you. Thank you for the strength that it took to come tonight. to
Thank
be
you.
here.
Thank you so much, guys.
Good
Have
luck
a
to your
great night.
family.
Thank you.
So sorry for your problems and losses.
We have another request. I have to apologize to the other residents. This young lady came from Orlando and she has to drive back. We're just gonna call her. She's outside. If we can call that case. Next, it's also a fine reduction. I'll wait for her to come in.
And which number is it, Doreen?
It's in section 9 and it's 9.2. This is section 9. And the item number is 9.2. Address is 1110 Northeast 119th Street. This is for case number CEN 23-311, Adriana Montes Trust and Abundanza Trust. They are asking for a fine reduction and they will make their own recommendation, their offer.
Good evening. We submitted some paperwork explaining that.
Ma'am, bear with me, please.
Oh, sorry.
And can you identify yourself?
Bear with me just a second. Are they in compliance?
Yes, they are. They are in compliance, and we worked with them to go through the whole process, and the building official finalized the permit.
I need you, please, ma'am, to identify yourself and your relationship to the property.
Yeah, my name is Adriana Montes. I'm the trustee for Abundance Trust.
Please make sure the mic is. There.
Adriana Montes, trustee for Abundance Trust.
Any questions and any questions from the board for the property owner?
No, I just had one comment. I was looking over when the date of the fine was to begin. It's just a small technicality, but it should be December the 1st, should be the first day
Of December.
of the fine. And that would only be 91 days, so it's $250 too much.
Hmm.
I mean, I'm looking, I believe it said,
At the order of enforcement?
yes.
Oh,
Yeah, it said imposed and shall commence on the 1st of December 2023.
thank you for that.
So I come up with a total of 23,500.
That's what I got.
And I want to explain that we got a notice of non-compliance and we submitted paperwork for a permit for the garage along with a permit for the porch. And based on that, we would have been compliant, but we were then later asked to separate the permits. And then that's when I deferred to the contractor and he was working with the city on that.
Hi, my name is Gilbert Velez. I am the project manager for Cooham General Contractor. When I first seen the fine, I went to the association, to Village Park, and I asked them what was their guidelines to help me legalize the slab that was done. And there was another fine for a driveway that has not on the code because it's cracked or whatever the situation is. So we actually recommended to remove and redo a driveway. So there was a lot of documents that needed to be presented. And being that we never worked with Biscayne Park, I was asking for guidance, and that's where the communication was not accurate. And we went as far as getting an engineer to actually give a letter that they were going to start building the plans that they were going to do. And we were told to do it in one plan with the back slab and the driveway all one process. Then we found out that you have to do a survey before you do that in this county. In other counties, you don't. So then we had to hire a company to come do a survey so we can present all the documents. But the letter from the engineer, as we were told, misunderstanding, was that with that letter being served, that the fines will stop at 250 after the fact. And this is where the whole confusion has occurred. And time had taken its place. And then at the end, they told us that we needed to separate the driveway from the porch. So then we had to do another application, permit application, and submit it separately. And that's what we did. We tried to comply, even though it wasn't probably on the time period that we were supposed to, because there was a lot of legwork that was being done. And we apologize for that, but it was not done intentionally, like neglecting the fact. We took all the initiatives that we could to try to make it compliant, to comply with the Village Park Association. And, we were trying to see if that fine could be reduced, because we weren't on the understanding that we were probably, I think, 2 days past the deadline, and then, but as Ms. Grant educated me the other day that we went to the office, she said that no, it doesn't, it's when you pass inspection or something like that. So it was all misunderstanding. So that's why we trying to see if we could plead that you can take that into consideration. We did follow, we did make all the documents that were needed to legalize everything and to make everything correct. And everything has been approved, and the slab was already final approval. Now the driveway has not been started, which needs to get started, because to my understanding, we got an approval, but we got 6 months. Is that correct?
That's correct.
There's a lot of things, but I will see if the village could actually help us with that. And we're trying to do the 250 fine to reduce if that's possible.
And if I may add, there was a real communication breakdown between what the contractor was told, and he had been to the office several times.
Yeah.
And when I met with the property owner, I could tell that she had no idea what the contractor was doing or what was expected of him. I literally had to get both of them together one time in my office, go through step by step. They sat in my office over an hour for us to get with the building official until everything was completed. They did their application, and I asked them to make the recommendation for the amount to the board.
It was your recommendation that he request that amount?
The owner.
So the
I
two
mean, I
fifty,
did not recommend, give them an amount. I walked them through the process and asked them to make a recommendation.
okay. And the communication breakdown that you referenced that he talked about, was
It-
that from a prior employee that was here, or was that with you?
It wasn't with me personally, it was with the department, the building department. Like he explained, he hasn't worked in Biscayne Park, and there were some things he didn't understand, how other cities operate and how they would do an after the fact permit. So there was a communication breakdown on what he understood he was supposed to do, what documents he was supposed to bring over to Village Hall. And I was witness to him and the property owner. She almost fired him in front of me, but I said, don't do that. It's just a misunderstanding. Let's work through this. And we did, and here we are.
And what kind of time do you think that you put in with the department and trying to, work this out and work with the contractor and the owner?
I would say the standard 250 would meet what we've done on this case.
And everything is compliant, it's all passed and they did everything. And the timeline that he described is accurate from your understanding?
I made sure they didn't leave my office until we completed everything.
Okay.
The village is satisfied with the, or would the village recommend to the board? No, not recommend. The village is happy with the outcome of everything to date, and the resident property owner has been working with the village to bring this all to a resolution.
That would be accurate.
Yeah, our job is not to punish. Our job is to gain compliance, and we're trying very hard to do that. But balanced on the other hand is we have to look at the interest of the village and how much it costs us and our employees to do the work as well. So we're trying to find a balance here.
Particularly when it involves work that commences without a permit, you don't know the safety issues that are potentially involved and how are things properly anchored? How are they proper inch-wise of concrete and all of those little technicalities?
That's correct.
That's one of the most serious time-consuming things from the village staff standpoint to go back and make that right.
That's correct. And the building official had to stop him and asked him to bring an engineer's letter, meaning an engineer had to certify that job.
I think that's something we have to take in consideration. This is
A lot of time.
not a low cost to the village, particularly this type of violation.
If I may add, we filed the permits as per the deadline for any violations to be imposed. And the permit was filed before that deadline of November 30th. It was filed,
I'm understanding you.
the permit was filed, the original permit was filed along with the driveway and the porch together on 11/14. Our deadline was November 30th to file the permit. We did file on time, however, he was advised to file all under one permit. The slab in the back as well as the driveway. And later, he was advised that no, that it needed to be filed under separate, that permit was only gonna go towards the driveway instead of the back porch, which was the one that was gonna start accumulating fines on November 30th. But we technically filed before the deadline. If you look at the notes of the permit, he was advised to put it on the notes that this permit was also related with the same plans for the slab. So I don't think it's fair that we are penalized when there was some misunderstanding, miscommunication from the building department towards him to file the two issues under one permit. Otherwise, we would have never started accumulating fines if they had gone back with the permit of the driveway, which is the one that was entered on November 14.
Anyone has anything further to add? I think we're probably ready for a motion.
Does the board understand what she just explained? Yeah, they have two violations open. There's a violation for the driveway and then the slab that was installed in the back without a permit. When he submitted the plans, he included both things on the same plans. So they did comply, like she's saying, with the permit application before the November 30th deadline.
Thank you.
Given the testimony of the property owner as well as the village, that there was an attempt to come into compliance by meeting the deadline, I'd like to, I make a motion to accept the
I'll
second.
that.
Yeah, I have a motion and a second. All in favor, please say aye.
Aye.
Aye. Any opposed, please say no. Motion passes 5-0.
Thank you.
Thank you both.
We'll now move to old business of the agenda. First item, 7.1. This is for the property located at 590 Northeast 119th Street. The case number is CEN 23-468 for Danielle Karen Alvarez and Joseph Alvarez. They are asking for a 30-day continuance to go through the planning and design review I think they had this discussion already on March 4th. Yes, they did. We did the agenda before March 4th. And they're here to give us a progress report. This violation is for a driveway. I'm sorry.
So my question is, it's still hung up at P and Z, Planning and Design Review, excuse me. It's still hung up there?
Were you approved at P and Z?
We were there for discussion. Good morning.
For
and good evening.
discussion.
First of all, Madam Chairman, members of the board, Danielle Alvarez and Joseph Alvarez, property owners of 590 Northeast 119th Street. We met at the Planning and Zoning Board and we were up for discussion. We had some clarification regarding the swale because we weren't sure about the parking status there. The Planning and Design Board did a great job of clearing that up for us. They gave us some design ideas. Right now, we're in the process of locating a contractor and going through with the survey process and all that stuff.
I'm okay to a degree with a continuance, but what my concern is, we've got to put something that gets a sense of urgency out there without putting at least some deadline, which if it gets hung up with P and Z, they can, you folks can always come back and ask for an extension then. But if we just keep going continuance after continuance with no endpoint that they need to, kind of try to achieve, then we're at this like forever.
Well, but at the same time, trying to get a survey is not an easy thing these days, and trying to get contractors is not an easy thing.
We take
So-
that into consideration.
So I
of setting a
don't-
deadline.
as well, and I don't have a problem giving a 30-day continuance.
I don't either. It sounds like they're doing their due
As
diligence.
long as it's moving in the right direction, you make me happy.
Thank you.
Oh, wait a minute, we haven't voted or anything. I'm in somewhat of agreement with Janie in that I think we should give a deadline, and then if it's not met, even if
You come
it's
back.
60 days,
Correct.
then you come back, because within 60 days, hopefully you would have already had several several opportunities to meet with the Planning and Design Committee Board, as well as to secure a survey and a contractor. And if not, then you can come back before us and ask for an extension. But I'd like to see a deadline also, instead of having it come back again next month, which is rather short time if you haven't even gone to P and Z yet. Or you don't have the survey and you don't have the contractor. So
Agreed.
I find that we would just be, once again, extending it, whereas it's 60 days, something should be done, and it would give you.
There's a concrete deadline. We don't need to see you, say, for example, next month. You're working on it, but you guys take a look at tonight's agenda. We've just got way too many continuance after continuance after continuance with no end game. At least by giving these folks who have been terrific about working with the village and trying to do the right thing, but at least give them a goal. They'll make the attempt to meet it. If they've done everything possible and they still haven't met it, it's still haven't found a contractor, you're still working with P and Z, you come back, you ask, we extend.
I think it's all reasonable. The question is 60 days, which
60
I
enough.
floated, is a reasonable time to do the things that you think you need to do?
Or is with
Given our
90?
difficulty finding a contractor and a survey, perhaps a little bit more time,
The
maybe.
survey shouldn't be that hard. The contractor could be a harder thing.
No, the surveys have been difficult for people to obtain from what I've
We
seen.
go 90 days? I would be fine with 90 days.
Thank you.
90 would make me happy. It's still moving in the right direction.
Yes, I will. As soon as I get to my calendar. Okay. I would like to make a motion in, case number CEN 23 468, give the property owners until June 4th to come into compliance by pulling all necessary permits. If that becomes an issue, you haven't made it through P and Z, if that's the problem, if the village side of the issue is the problem, come back and ask for an extension. Other than that, June 1st, I'm sorry, June 4th as a compliance deadline. If not, as of June 5th, there would be a $250 daily fine
Very well.
and a $250 administrative fine. But again, if you come into compliance by June 4th, or come with evidence that, yes, you've done your due diligence and there's pieces still missing, and ask for the extension, then you're fine.
I have a question. If the permit's in process, will we still have to come by on June 4th and present and say, hey, this is where we're at, or?
We need to know the permit is
Okay,
in your hands,
got it.
not just in process, but in your
Or,
hands.
I mean, if it's, if the situation,
not-
if the project's in process, do we still have to come before the board?
Yes, the progress report, you can come back to us and we'll report to the board.
Got it. Very well.
Well, what happens sometimes is people get approval for a permit and don't actually pull the permit and pay. So understand that you're not in compliance of having a permit until you've paid and pulled the
I'd like
permit.
to second, and then I'd like to add something. Because if I understand, your motion is to pull a permit by June the 4th, if not, a $250 per day fine.
And the $250
Plus a
admin.
$250 admin
Correct.
fee. My question is, if they do that, they don't need to come back to give us a progress.
no,
No,
not
that's what
Doreen.
I'm asking.
They need to give it to Doreen.
No, you don't need to come back.
Okay.
Because basically, you would make sure that the village knows that you pulled the permit and you're in compliance.
Okay.
It would not come before us.
You don't have to.
I don't want to, we don't want to find out about the meeting after the fact and watch on TV.
For the evening here, sir. You don't have to do
All
that.
right.
Scintillating.
Shall let me repeat my motion so that it's clear. That we ask for compliance by June 4th, which means you pulled and paid for the permit. If not, $250 daily fine, $250 admin fine. Do I have a second?
I already
Second. All in favor, please say aye.
Aye.
Any opposed, say no. Motion passes 5-0. Thank you both.
Thank you, Madam.
Clarity.
Members of the board, have a good evening.
I just wanted to get some clarity. The 250 administrative fee will only be
Only if they're
assessed
not-
after, okay, without compliance. I got it.
Or if they're not in compliance and they show up to give us a progress report. So if you're,
If the non-compliance has to do with something village's side versus like not paying or something, two different ways.
Thank you.
Thank
very much.
you.
Have a good evening.
I'm gonna apologize to the residents again. We have another request. We have an elderly resident, Miss Alette. She's very uncomfortable and I'm gonna have to call her case now. This is in section 8. And the item is 8.16. 8.16. The address is 1192-23 Northeast 12th Avenue. The case number is CEN-23-339. This is for Arlette Romaine and Jean Pierre. We're asking for an order of enforcement for a driveway violation. There has been no permits in the system. We've communicated with Ms. Arlette and she's here today to give her own testimony.
I apologize, Doreen, agenda number again, 8.
It's in section 8. Agenda item number is 8.16.
Oh, I'm sorry. That's 810.
810?
Yes.
So I called the wrong case. I'm
Yes,
sorry.
yes. Sorry.
He gave me
10921 Northeast.
10921 10th Ave,
10921.
Yes,
10th Ave.
10th.
I apologize to the board for that.
May as well.
So it's 8.10. Property address 10921 Northeast 10th Avenue. The case number is CEN-23-282. It's Marie Rodriguez and Pontville.
Tito Pointville, yes.
Peter Pointsville. Apologize for that. We're asking for an order of enforcement. This is for a driveway violation. There are no permits in the system. We did go to the property. We were unable to make any contact at the time.
Questions from the board?
Yeah, Yes, does the property owner reside at the property? I just
yes.
noticed that it's not a homesteaded property.
It should, yes, she does. No, why it's not a homestead, it should be.
Pardon?
I said she does.
It's a,
No,
it's a duplex?
Homesteaded property.
So
It's a duplex?
Yes,
So is one side rented?
yes, it is.
Okay, so one side rent, one.
So Doreen, when you say that there's no permits in the system, does that mean that that was a driveway that's been there for that long or that it was put in without a
we have the
permit?
file. I'll look at the file and tell you exactly when we issued the violation. This violation, I believe, was issued last year, August?
August.
Yes. So since then, we haven't seen any activity on this particular violation, and we did try to make contact. We went to the property, knocked on the door, there was no answer.
Remind me again, the original deadline for driveways was actually January of last year. Am I
That's correct.
And then what did you do in August? You gave her, was it a violation or warning or what was it?
We first issued a courtesy notice. This was January 2nd of 2023. And in August of 2020, I'm so sorry, that courtesy notice was issued May 6, 2022. I apologize for that. We gave them, right, the compliance date for that was January 2nd, 2023. That's what I was reading. Now, we went back, we inspected the property, there was no compliance, and in August 2nd, 22nd, quite a few months passed, 8 months, we issued a notice of violation. They're still not in compliance now, and there is no activity, like I said, in the system.
Almost 2 years past the courtesy notice and 7 months past the notice of violation.
And no response, no communication.
So, and this is Marie
Yes,
Rodriguez?
Rodriguez, Rodriguez,
Rodrigue.
Yes.
And who are you?
Ito Pointville.
And you live there too?
No, I don't live there.
Okay. And what's your relationship to the property?
My mom.
Your mom, okay. And did she live there,
Been there for 20-something years,
okay.
probably close to 30, actually. I think this year's gonna make 30. Yes, she's been.
So so there was some courtesy notices and there was some issues with regard to communication. What
Well,
what
the
do we
thing is,
say?
I don't live there. I try to maintain and help out with the property as much as possible. There were some other violations. I think it was like the roof. I had somebody swing by there and they pressure washed it. Something that they said they couldn't read the numbers on the house. I went myself and put bigger numbers. Now, the thing is, I went down there a couple of times because I had to pay a fine. And I was explaining to, just the same way when I was putting the roof on the property. Now, I understand the beautification of the neighborhood, but it comes at a cost to us. It comes at a cost to her. She's 77 years old with her income. Now, and I explained that at the time to the village when I came over here. Though these things is, it's almost like you're saying that you're not trying to penalize the people that live here, but the rules that's been implemented is penalizing the people that lives here. Let me finish. Now, yes, I understand the driveway that's there's been the original driveway since we bought the property. Now, at the same time, I don't know what section 5.6 of the driveway code that's been expanded. She has one car, the other neighbor has 2 cars. Now, there was a point where they were parking kind of on the grass. This is what I was told on the fine. So I told them not to park on the grass. They parked back to back. They did have somebody else there at the time, but again, they've continued to stop doing that. Now, my thing is, what do we want to do with this driveway, and who's paying for it?
We don't make the rules. The rules are made by the commission. Our job is to enforce it. Prior to the commission redoing the driveway ordinance, there's always been a requirement for driveways in this community. And the driveway for a duplex, I believe, requires 4 spaces, 2 for each side. So Doreen can be more explicit on it. So, but
Rafael.
this the driveway you have only has one. So under any of the ordinances, at least since I've been here since 96, you're not in compliance with the prior ordinances or
Well, like I said, she's
anything
been
that
here
I'm
since
aware
90.
of. But again, it's not in compliance with any of our ordinances. And it
Since-
hasn't been
Since 1998.
since before then. Yes.
I just have a question of the code officers in the village. Has there been any communication with regards to resolving this issue in the past 2 years to bring out some type of resolution? What type of items might need to be done? How we can go about doing it? Anything from the residents or property owners to the village?
No, there's been no communication. When we issue these violations, we ensure that we add the entire ordinance, and it's a 2-page document. When residents come to Village Hall, we do give them the flyer that shows what type of driveways they can do, but we haven't really had any communication with this particular resident.
You said your name is
Law has always,
Vito. Okay, Vito. With regard to the communication, was that something that reached to you? Like, did your mom talk to you about like?
Well, again, she lives there by herself. She's there. I don't live there. I have to do, again, if I'm speaking because I do a lot.
You
of
speak in the microphone, sir? Thank you.
I say I'm speaking because I do most of the, try to do, help out with most of the heavy lifting, obviously, as you guys could see. So, I mean, I do apologize, certain things fall through the cracks. Obviously it has, but I have gone down there, like I said, and I've spoken especially about these issues and with the fines that were held out before.
What about like since August, like when the violation came in? What we just heard was that there was no communication since you're communicating for your mom.
Well, again, if somebody's coming by there and they're probably sending a mail or two or what have you, like you guys send, like you send this notice, I try my best to acknowledge them. Again, I'm running my own household in a sense. I'm working. I mean, I'm here. I'm helping. It's my mom, but like I said, certain things fall through. And question I asked before is, I'm sorry, Miss Judy.
Emmelberg, yeah.
Okay, you stated that those complaints was here since before then. Well, in '94 she bought that property, and nobody told us that it was not in compliance then as well.
but
When we
sir,
bought it in '94.
the fact that the village may have not as stringently enforced this as they are now doesn't negate the fact it's not a new ordinance. There's been some minor tweakings to it, but it's not new. And it's being enforced with everyone. We work with folks as much as we can. We've had other cases very recently that we've done our best to work a timeline with them. But you can't just ignore 2 years' worth of notices from the village and not make that communication effort so that things can be worked out. So that's what puts us where we are now tonight. We can't pretend, we can't selectively enforce an ordinance deliberately and say, well, for some folks, we're just not going to worry about it. Can't do that.
Okay, I'm not stating that as well either. All I'm saying is I have a few times come there and expressed with this parking.
And you know, there
situation.
are various ways. I mean, it does not, there are numerous types of materials for a driveway for the minimum that you'd be required to do.
And what is?
Are more reasonable. I would strongly urge you, if you don't already have the paperwork from the village that details what types of driveways and the materials are acceptable, excuse me, and how much parking space you would need because of it being a duplex. Obtain that material, work with staff, but we've got to get a timeline. We've got to get it moving.
Okay, I'll swing by tomorrow afternoon. And
Say if there's no questions, I'd like to make a motion.
Please.
I'd like to make a motion that a violation has occurred. Give the property owner 6 months, as we have with other hardship cases, to come into compliance. If
Give a date.
Huh?
Give a date.
All right, 6 months.
September, you want to say September,
Whatever,
okay, September,
third week.
September 16th would be the third week. September 18th?
the 18th. If not, assess at that point, assess the fine of $250 and a daily fine commence on the
19th.
19th of $250 per day.
So you,
Administrative costs of $250.
so compliance by 9/18, if not a 250 violation fine, a 250 admin fine, and 250 daily.
Right.
I'll second.
I'll second.
All in favor, say aye.
Aye.
Any opposed? Say no.
Please come and see us, Mr. Fido. We'll work with you.
Okay, all right, thank you.
Thank you, sir.
Thank you.
Thank you for your time.
Appreciate it.
Work with the village, sir.
All right.
Please.
Moving back to old business, which is section 7 of the agenda. Item number 7.1. This is for the,
7.2.
we did one, I'm so sorry.
7-2?
So it's 7.2. Item number 7.2 for the address 665 Northeast 117th Street. This is for case number CEN 23-364 and to Views LLC in care of their registered agent, Maura Gloria. This case was continued for them to get permits for paint, which they have. I would like to enter into the evidence. Permit number EPP-24-2. They have communicated with the inspector and the inspector can give an update now. Rafael.
Hello, Rafael Gutierrez, Co-Compliance Officer, Village of Biscayne Park. The property owners of this property have applied, as Ms. Grant stated, the paint permit is in place, and they also have applied for the stucco finishing for the property. So the job is in progress, ongoing.
Now, progress, or do they actually have the permits?
Yes, they do. Yes, they do have the permit.
Okay, paid for, and they have them,
Let me double check.
please.
I just want to be sure.
Stucco work.
The paint permit has been issued. The paint permit has been issued. The stucco is not, the stucco issue is not on this agenda. It was for paint. The paint permit has been issued. That's correct.
That's all we're worried about at this point, is the paint permit. So, any other comments?
No comments, except that we are asking that you grant them this continuance. They are a new owners and they are working on fixing the property.
The permit, there's really,
They have painted it, haven't?
well, they don't.
Let me just clarify something. I'm just going over the records. So the paint permit has been issued for the paint. The stucco has not been
We're worried
issued.
about the stucco.
I'm sorry.
It's the only-
Oh, the paint, yeah, the paint, that has been issued.
So they really don't need a continuance. They have the permit, right?
That's correct.
That's what I had written down here. Why?
Good.
Continue.
No?
They've got a permit.
Correct. Except this particular violation was not issued for a permit. This particular violation was issued for them to paint the building. Now, they want to do some stucco work first. And they have applied for a stucco permit. Now, I didn't want that discussed because we issued the violation for them to paint the building.
They really can't.
Right, and so they've come into compliance with regards to what they
So,
were.
Right, which is they have the permit, but they still need to paint the building.
Paint permit runs out, then
They,
it's run out.
That's correct. They have 6 months.
however, they have the time.
In case number CEN 23 364, I'd like to make a motion that they're in compliance and to close.
I'll second. All in favor?
Aye.
Opposed? No? Motion passes 5-0.
The next three cases are 7.3, 7.4, and 7.5. These are for the property located at 739 Northeast 111th Street. First case number CEN 23-299. For the second case number is CEN 23-300. And the third case number is CEN 23-303. This property is owned by Brett Anthony Frey. They have been in violation with exterior paint, section 16.3.1, re-roofing, I would say roof repair because they have a roof that's caved in, and that's a violation of section chapter 16-9. And for the street address affixed, which is missing a number, violation of section 11.125. I'm reading these three cases together because we are asking for an intent to lien for all three cases. We tried to, I will say this, the violator has had several cases in the past, liens filed, and has never made any contact with the village. We have reached out several times, but we have never met this gentleman. Yesterday, I asked the police department to do a welfare call because we have never seen who owns this property, and it's severely damaged. The whole roof on the garage side is caved in. The chief of police and the deputy chief made a welfare call to the property. They met the elderly gentleman that lives there. They said he is okay. He was able to speak with them. So we are asking to go ahead and issue liens, intent to liens for all three cases.
Any comments?
No, I was just gonna comment, you answered my questions, which has precedent for property owner been in communication with the village or anything, so I have no further questions than that.
Doreen, is he aware that he's in violation?
We have sent certified mail. We have obtained service, meaning we have sent certified mail. We have posted this property several times.
Is he capable of understanding? You don't know.
That I would not be able to say. I've never met him.
Just,
We're not in a position to make that judgment.
Absolutely not.
Wouldn't want you to.
okay.
Yeah, if there's no questions.
Make a motion?
I'd like to make a motion, and I'd like to make a motion on all three of them at
Sure.
once. On case number CEN 23 300, case number CEN 23 299, and on CEN 23 301, to request that the village move with filing the lien, plus the filing fee on each of the separate citations.
I'll second. All in favor, say aye, please.
Aye.
Aye.
Aye. Any opposed? Motion passes 5-0.
The next case is item 7.6, 740 Northeast 121st Street. The case number is CEN 23-389. The owner is Elaine B. Amiel. He's here tonight. This violation is for a driveway. There is no permit in the system as of today, but we have been in communication with the property owner.
Good evening. Alan Amiel for 740 Northeast.
You let the board
Okay,
ask any questions?
a little anxious.
No, if no questions, then go right ahead, sir. And if you want to
Alan
begin.
Amiel for 740 Northeast 121st Street. Good evening. And based on what I've heard this evening, I'm looking pretty good. Because I have a contractor, I have my plans, I have a survey, I started all the paperwork. I was actually gonna submit on Friday or tomorrow because I thought the hearing was Friday. Until I got an email from Raphael. Thank you, Raphael. I raced over here. I literally thought it was Friday. So if you didn't send that email, I would be in trouble.
So if you would speak into the mic.
So I'm ready to rock and roll. I just need time to get a permit, and that's it. I got a design that's relatively simple. It's gonna be approved by PZ. I've already run it by one of the members. If you guys want to see a picture, I got a picture.
So you're ready to go apply for the permit?
Very nice. Yeah. Fit your house also.
So that's my story. I'm sticking to it.
Great.
So,
Thank you, sir.
they'll
Actually,
be,
keep that copy because
absolutely.
that does have to go with the file.
and I believe
Oh, but so, but he
Okay.
entered
Yep.
into it
Okay.
to show us that it does have to go with the
there'll be two more, planning and design meetings by the end of April, correct? April the 1st and April the 15th. Have you already submitted your request
No.
to be heard?
No.
Because if you submit it
He's doing-
by March the 25th, you can be heard on the next hearing.
Okay,
If
that's,
you have everything together.
I
If
do.
not, you'd have to submit it by April the 8th to be heard on April the 15th. So all of that said, I'd like to make a motion. I'd like to make a motion to give the property owner until April the 30th to come into compliance by pulling a permit. If not, assess a fine of $250, administrative costs of $250, and a daily fine to commence on May the 1st of $250 per day.
I'll second.
Oh, go ahead. Judy
I'll
second.
second it.
All in favor, please say aye.
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 Any opposed? No. Motion passes 5-0. Thank you, sir.
I have entered into the evidence a depiction of what the driveway will look like. Moving on to new business. First item in section 8 is 8.1 for 739 Northeast 111th Street, CEN 23417. It's again for Mr. Brett Anthony Frey. This is the gentleman with the three intent to liens that we just confirmed. This is an open violation for a driveway, a violation of section 5.6.7. We are asking the board to issue an order of enforcement for this violation.
Any questions? If not,
Doesn't look like that driveway's been driven over in years.
If no other questions, I'd like to make a motion in case number CEN 23-417 that a violation has occurred. Well, no. To give the property owner until April the 30th to pull a permit. If not, assess a fine of $250, administrative costs of $250, and a daily fine to commence on May the 1st, $250 per day.
I'll second. All in favor? Aye.
Aye.
Any opposed? No. Motion passes.
Next case is item 8.2 for 767 Northeast 114th Street. The case number is CEN 23-284. This is for 767 Northeast 114th Street LLC in care of their registered agent, Right Angle LLC. We're asking for an order of enforcement on this violation, which is for a driveway They are found to be in violation of chapter 5.6. No communication, no permits.
Doreen, is there a driveway? I don't even see like an actual, I see a car parked in the grass, but is that apparently the driveway?
There is no driveway and they have to, they are in violation of the driveway ordinance. They have to install a brand new driveway.
There's no like, access street behind the property?
We, inspector, we don't believe so, but is there an access in the back?
No, there's no access to the rear of that residence.
You know what I'm talking about, right? The access road,
There's
the alleys, right? Okay.
Yes.
no.
Has there been any communication with the resident or from the property owner?
7/14. We haven't heard from them. Did we call them?
If there are no further questions or comments, we'll entertain a motion.
Well, yeah, no, I just noticed that this is not a homesteaded property.
No.
Just for the record. And you gonna make a motion?
Okay. In case number CEN 23-284, we find that a violation does exist. Give the property owner until April 30th to come into compliance. If not, a $250 fine, $250 administrative fine, and a $250 daily fine to commence on May 1st.
I'll second it.
We have a motion first and a second. All in favor, say aye.
Aye.
Opposed? No. Motion passes 5-0.
The next item is on 8.3. This is for the property located at 820 Northeast 119th Street. The case number is CEN 23-106 for Anthony Tavares. They are requesting a continuance. We are requesting this continuance. This property owner has been in touch with us. He is deployed into active duty by the federal government.
I would make a motion to grant the continuance.
I'll second that.
All in favor, aye.
Aye.
Do we give a date to when the continuance?
He does ask till next month. He's back the end of the month. Right. I'm sorry, you're right. I should have been part of my motion. My motion is to continue until the April meeting.
Next case is 8.4, 820 Northeast 119th Street. Case number CEN 23-415 for the same resident. We're asking to close this case. After reviewing the case, I realized that the case that we just called before was identical. Even though we use different sections, we issued the violation for the same violation.
I'd like to make a motion on case number CEN-23-102. Oh no, in case number CEN-23-415 to close the case.
A second.
All in favor, say aye.
Aye.
Any opposed? No. Motion passes 5-0.
Next item, 8.5. This is for the address 859 Northeast 115th Street, case number CEN 23-294 for Juan Sebastian Pesantis. He was found to be in violation of the building ordinance, which is 16.313.1. He did construction work without a permit. Mr. Pesantis was in our office today. He's asking for a continuance. He's working with the building department now to close out a plumbing permit that they had applied for in 2023, but did not final. It was for a bathroom sink and toilet that was installed.
Yeah, this was back in August of 2023, and from then until today, you said?
That's correct. Mr. Pesantis had explained to me that just like the other gentleman, there was some miscommunication. When he came to the building department, the information he received, from what he said, he understood that he wasn't supposed to get a permit for installing a toilet. So he left this alone until we contacted him and told him that he needed to close this permit. The violation was still open.
So he had pulled a permit.
He did pull the permit. He didn't get a final because in his mind, when he came and was told that he didn't need a permit to just install a toilet, I couldn't verify that, but he said. We did issue a violation for the trash, but that one closed because they removed the trash the next day.
I reported it back in.
He did, like, the next day after we issued the violation, he applied for the permit.
Requirement, I'm getting a little confused. He's complied now, he has the permit.
The permit is still open. It wasn't final. It wasn't closed.
Has he paid for it?
Did he pay for it? He paid today.
It's paid. Okay, because what we have, okay.
Right, when I reviewed the permit, there was no payment, actually, I have to say. So he came in, paid for the permit. Now the permit is good. So he has to call for a final.
All right.
Then. So he's asking for a continuance so he can go through that process.
Why would we
Right, we wouldn't. if he
Well,
has his permit.
I would like to make a motion, if y'all entertain it, in case number CEN -23-295-4. Give the property owner until April the
24th?
because basically all I had to do was pay and
Yeah,
get, and
exactly.
call for an inspection.
Mhm.
April the 24th, to, close out the permit. If not, assess a fine of $250, administrative costs of $250, and a daily fine of $250 commencing April the 25th.
Second.
Okay, we have a first and a second. All in favor, say aye.
Aye.
Any opposed? Motion passes 5-0.
So that gives a continuance in.
There's this
essence,
continuance.
And it doesn't have to come before us.
Next item is 8.6 for 1040 Northeast 119th Street. Case number CEN 23-297, Giovanna L. Children's Trust and Marie C. Lodato Trust. We're asking to close this case. It's now in compliance.
I would make a motion in CEN -23-297 that the property owner is now come into compliance and we close the case.
Second.
All in favor, say aye.
Aye.
Any opposed? Motion passes 5-0.
Next item, 8.7. This is for the property located at 1107 Northeast 117th Street for case number CEN 23448 BP Park 110 LLC in care of their registered agent, Ilmax LLC. This property owner just bought this property. They just closed on this property and they're asking for a continuance of 2 months in order for them to demolish this property and submit their plans for the new house that they'll be building on that property. They are aware of this violation, so was the previous owner. We did explain to them that this violation will move to the new owner, and until they get in the plans and do what they need to do with the demolition, this violation will remain open.
I kind of would recommend we give them more time than that because they can't get a demolition plan until they put forth their building plans.
Yeah, I agree.
So,
I thought that too.
Oh, yeah.
They have
correct?
you can't force building plans anymore.
Yeah,
If
so
somebody
as of
looked at it-
January, you're allowed to pull a demo permit without needing any other plans.
So
Thank
Should I
you.
introduce myself as a resident or planning and zoning member?
You're
I
both.
can Do either. So David Gruen, David Gruen, 11520 Griffin Boulevard. As of January now, anybody's allowed to pull a demo permit without needing to have approved master plans.
Okay.
So
Thank you for that, David.
that's a state law. That's not a
State
Biscayne
law
Park.
changed that?
Oh, yeah.
what I
No, we wouldn't have changed that. Thanks.
So in reality, I think I look for an end game where a client, you know, where a property owner has some level of responsibility because they've got to meet a deadline or come back and explain why they couldn't, but not just kind of this open-ended, we'll see you next month sort of thing. There's no reason it should take them that long.
Can we do 3 months?
I'm not sure if they were aware of the change in the state law, but we'll be happy to communicate.
Because
to them.
that's why the commission had to change our ordinance because state law preempted it.
Okay.
And you can't require plans anymore.
Also, I think as somebody who just bought the property, we should be giving them fair time.
They bought the property in
Agree.
November.
I'll make a
No,
motion.
no, they just bought that property. I don't think
bought
that, yeah. The old owner just moved out on March 11.
I'll make a motion that in CEN 23-448, we give the new owners 3 months.
90 days.
Gotta have a date. Okay,
Calendar.
so. that
June.
would be,
June.
June 20th?
June 20th to pull permits. And
Can we make it a Wednesday? Let's make it even, June 19th.
June 19th?
Juneteenth? That's a holiday.
Oh, it's a Wednesday. Okay, June 20th, then she's right. Judy's right, excuse me. Okay, so you're giving them till June 20th. I'm sorry for.
To pull permits, right?
Okay, or
Or it's the $250 fine and the $250 administrative and the $250 daily unless they come talk to us and ask for something different.
I'll second. All in favor, say aye.
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 Any opposed? Motion passes 5-0.
Next item is 8.8, 10901 Griffin Boulevard, CEN 23-59. Property belongs to MPMR Holdings LLC. They were found to be in violation of a swimming pool that had a fence that was non-conforming. When we issued this violation, we also posted a safety hazard notice. The property owners at the time did come into City Hall to find ways for resolution, but then they disappeared. We hadn't heard from them for a while, and I asked my officers to post the safety hazard sign again because the fence that they have cannot protect animals or young children from the swimming pool.
Can I ask, only because when I see documentation like this, I can't not. Does the swimming pool have a permit?
The swimming pool is an existing swimming pool. It's been there for a long time. However, the fence is too short it does.
No, my question is, how do we have a pool that's final with a 2-foot 8-inch fence?
He will answer that question.
Actually,
Sir, if you would identify yourself. and your
Lauren Jacobson
relationship
on
to the
behalf of
property.
MPMR and the
You know,
property.
to the mic, please.
Is it not? Lauren Jacobson on behalf of MPMR. I have other questions to bring forward, but that question you asked is part of our question. We did have work done on the pool permitted from the city of Biscayne Park, I think 2006 or 2007. 13? 2013, I don't remember. But we had the pool renovated and the deck replaced. Yeah, that's what I say. You can't tell if it's. We had the pool renovated. We had the deck renovated. It was permitted. The city came out and did their final and closed that permit.
Apologize for
Yeah.
interrupting. So you bought the property in 2013?
Is it 2013? Yeah, 2013.
So the
Wait,
pool
ye-
existed, obviously.
It was there when we bought it. We renovated it afterwards.
Oh. and the
My
fence-
years are off if I said 13.
You've never lived in the property?
No.
Because I know the people you bought it from and you bought it 11 years ago, but nobody's ever lived at that property, ever.
Right. It's beautiful.
My name is Maylene Raytor, and I represent MPMR Holdings LLC.
He's my husband, and we've been taking care of the property ever since we purchased it in 2013 from the Russells, a nice family that lived here. And the fence was already in place along with the pool. They actually added a new fence to the neighbor's side because their fence was falling apart. And before we purchased the property, the neighbor built a wall. And it was permitted and everything was fine. We purchased the property, but we never moved in because we have a property in Surfside and our children were going to school there. So we figure in the future, we might just move here. We come to the property every 2 months or so to check on it. We do have people that take care of the lawn and the swimming pool on a weekly basis, or monthly for the pool and twice a month for the lawn. So we received a notification actually from one of the workers that there was a posting on the door in March for violation because we have not received any documents. When we came to the properties, when we saw the violation, and we came to the office and met with Mr. Nibbs to find out what was that about, because obviously there was a permit for that fence back in 2002. And I didn't have the documents for it until we met with Mr. Nibbs and he explained all the violations, and we were willing to work with it and make sure that everything was in compliance. But when I pull the information from the records, it shows that a permit was done for that particular fence. So I didn't understand why 10 years later, now we have to redo a new fence and everything else.
Because it doesn't meet code. It's
Ah,
only
but-
2 feet, 8 inches.
So
Well, it's actually taller, but I guess over the years it made it the ground or something.
But, you know, and
But I'd like to just read for you, because the citation is for removal of non-conforming existing fence. That's what the citation's for.
Yes.
But in your code, it says 11.6.6, non-conforming fences and walls, any fence or wall which has been properly permitted, approved by the village prior to passage of ordinance number 2011-2, or existing prior to number 24, 1988, or which does not comply with the requirements of this ordinance, shall be considered legal yet non-conforming structure. Such non-conforming fence or wall may be continued until such fence or wall has deteriorated to the extent of more than 25% of the structure or has been damaged more than 50% of the structure.
May I answer to that?
That's the problem.
Yeah,
It surrounds a pool. And-
I get that, but it's,
The violation was for section 11.9.
Right.
It just says corrective action that can be taken. But the violation was for the swimming pool not
Right.
being surrounded by a non-climbable.
Take a look at your notice of violations.
and the fact that the property is vacant worries me more.
It was on March the 9th, 2023. So that's been a year. I just want to know from the village if there's been any communication since March the 9th, a year ago, until recently with regards to inquiring what needs to be done.
before you answer, can I
Well,
just add one more
yeah,
thought to
Yes,
his question?
I haven't finished, sir. I,
The board, if you would, sir.
if there's been any correspondence with the property owner as to how to rectify it since March since the notice of violation was issued a year ago. More than a year ago.
I will say yes, there has been communication, and this was right after we issued these violations. And I'll explain the violations. These were not proactive inspections from our officers for the same reasons he just read out in this ordinance. This was a reactive, meaning someone complained, and we had to go out there with a measuring tape and measure the fence. When we found out that this fence was only 4 foot something, how much was it again?
Of 4 inches.
It was about
Under-
4
no, actually under 4 inches.
It was under 4 inches when we measured it with a tape. 4 feet.
4 feet,
Forgive
that's
me.
correction, yes.
Under 4 feet. Now, when I looked at the photographs, when the inspector came back and I looked at it and reviewed the photographs, I see the swimming pool and I sent him back right away, go and post a safety hazard, because for a 4-foot fence with a swimming pool right in view, that was a huge liability for the village. So they came in, did their due diligence at the time and asked how they could correct this violation. And we gave them several options. They could cover the swimming pool. That would at least cover the safety issue. They could put a fence around or a barrier around the swimming pool, and that could, you know, keep away the safety issue while they deal with the fence issue. None of that was done. And like I say, we lost them. They disappeared for a while and we had to reach back out to them.
If I can answer the disappearing,
Mhm.
no, we did come see you, and we also went and started getting quotes and so on and so forth. When we learned of this ordinance and we had a question about it, which you're telling me I looked up the wrong thing, or the fence people looked up the wrong thing, we sent an email to Mr. Nibbs explaining the ordinance, the violation, and the code, and asked to please
And that I have
rectify it.
quotes from different
And here's all the
companies.
quotes, and we never heard back. And this is in April of 2013.
13.
2020.
That's what I'm looking for.
So we sent this to him. We didn't hear back. We did not get another notice on our door. We did not get a letter in the mail. We did not get a phone call until today.
I have to say, though, you've got a property that is completely open to a street, minus a 2-foot 8-inch fence with a pool.
Because
You know, do you
bushes-
need a
because
notice to
bushes-
tell you?
No, what happened was, and this is, she said they got a call to complain, right? There was big hedges back there. The hedges were becoming a disaster to everybody.
Okay, but that still doesn't satisfy Dade County's requirement
No, but
for a 4-foot
understand,
fence.
so it's been there for, since what, 2002, the fence? Which
Can we-
satisfied the
Go ahead,
Dade County at the
Councilman.
time, and
That can't be, because my pool's been in there since 2000.
And do you understand the liability you assume?
Yeah, that's okay.
Let's just stick to,
we don't mind to,
all right,
to fix whatever is wrong.
that's what I want.
But what we're saying is, we didn't disappear for a year.
Okay.
We thought, I even told Mr. Nibbs outside before and when they called today. I thought after the email,
Okay,
cases dropped.
let's get to where we need to go to fix this problem.
May I show you the quotes? May I show you the quotes for the company
I'm sorry,
that I
yeah.
met with?
Sure, but we really don't need the quotes. I mean, all we need to know is,
Don't need,
Yes,
Oh, because-
after we met with Mr.
I
Nibbs.
like the
Okay.
fact that he has a letter. That's why I was wanting to know about correspondence. I think you might need to enter that into the record, sir. Oh,
I mean, there's an email explaining exactly what we emailed back in April.
Hold on a second. May I say something about the communication? Since the company had an agent, located in Aventura, that's the address that is registered for the property appraiser. So I tried changing the address and they sent me a letter back saying that I had to send in some additional documentation. When I came to the office here, I gave my email, my address, my current address in Surfside. If anything needed to be sent, to please send it to me at that address or by email, because otherwise the mail was gonna get lost. We never received,
They did call today, thank you.
we did, the last notification I received was on Thursday from Mr. Nibbs, letting us know about the
So the.
the
what we need
violation
to-
station.
I'm sorry, apologize. What we need to do, though, is let's see going forward, what can we do to fix this? What is this board?
Not only on, we'll call it violation.
Oh, no, it's fine.
Okay, but I wanted to ask.
So David Gruen, 11520 Griffin Boulevard, Planning and Design Review Board. So just for clarification for both sides, the issues with it are actually at the state level under the Smart Water Act that was passed, which is so you can find this, and I'll email this because I know this needs to be submitted for the record. But it's section 515.29 subsection 1, and then A through D, by me reading this, what I'm saying is, even if Biscayne Park has totally different laws and rules and all of that, the state supersedes everything that we say, which is similar with the demolition, not needing permits from us and all that. So what it says, and I'll email this, and then I'm sure they can send it to you, and I have no problem sending this as well, but what it says is, it's subsection 1, a residential swimming pool barrier must have all of the following characteristics. Subsection A of .1, the barrier must be at least 4 feet high on the outside. Subsection B, the barrier may not have any gaps, openings, indentations, protrusions, or structural components that could allow a young child to crawl under, squeeze through, or climb over the barrier. Subsection C, the barrier must be placed around the perimeter of the pool and must be separate from any fence, wall, or other enclosure surrounding the yard unless the fence, wall, or other enclosure or portion thereof is situated on the perimeter of the pool, is being used as part of the barrier, and meets the barrier requirements of the section. And then last section, subsection D, the barrier must be placed sufficiently away from the water's edge to prevent a young child or medically frail or elderly person who may have managed to penetrate the barrier from immediately falling into the water. So I'm only saying that to say
You're
beyond us.
You're the only one here with the knowledge, understanding what you just read. So if I could just ask, in C, it's saying that would not be the fence outside, meaning if we're fixing this, we're not just putting a new we need a fence on the pool, not
No,
backyard fence.
what it's saying is your perimeter fence,
Right.
you do not need to have a fence that goes immediately around a pool. If the perimeter fence, you are then counting as the pool fence, but that means the perimeter fence has to comply with all 4 of those points.
But, so if we put a better fence on the outside of the yard, we don't need a.
No, you don't need a second fence. No.
For the pool.
Or if you put a better fence just around the pool, you don't need to do the whole yard.
Whatever they call it,
Okay.
kid fence.
May I-
If you folks would, we need to wrap it up.
Yeah.
Please give us the time. We waited for everyone to go in front of us, and we've been patient enough. I think this is important. We are a family, we have children. My son just went to college last year. I explained that to Mr. Nibbs. We didn't have the funds to put on a brand-new fence at the time. I did get the quotes from 3 companies with different options, and it's a lot of money. It's over $4,000, and who
But that's
has that?
without removing the trees. They need to remove all the trees that are not ours.
What
So-
about a barrier just around the
Right,
pool?
So
that's
I
what
got
we
a quote for
That
that. That
should-
was $2,000
That's what we
plus.
discussed, except
Okay.
what our thought was, right? So we're not saying this is what it is. What our thought was, because we had the pool done and our permit was finalized, we didn't think we needed that.
Why
'Cause
didn't they
have
say
to
something then?
Now
that-
drill into the marble deck and make big holes in the brand new deck when they didn't tell us then, so we thought it was. good.
Why is it that one phone call 10 years later from God knows who, the
The lady
upper.
who yelled
son-
about the tree.
That doesn't matter.
That's all it takes.
So-
The fact is, you're really not in compliance. The result is, what are we gonna do? How much time frame do you need? So, is there, I've heard, I
To
mean,
get into compliance, I need to put something around the pool or a new fence. So
Yes.
I
Got
need.
to be at least 4 feet. You heard Mr. Gruen read the code.
Thir- 30. Yeah,
All right.
To start, I don't know how long it takes the fence people to get a permit from you guys. Does it take a day or does it take a week?
You know, I don't understand. This is a serious safety issue. I think we should all be working together to get the safety issue taken care of, not sitting here and saying, oh, because such and such happened 10 years ago. It's now 2024. We need to fix this.
It's going to be fixed, but we need the time because we need to
How
collect
much
the money
time?
and
You need
find the
2
vendor
months,
that
3
can do it.
months?
2 months.
2 months.
all right,
More than enough.
on case number CN-23-59, find that there is a violation that has occurred. Give the property owner until, what is 60 days?
Let's say May
May.
22nd.
So May the 22nd to come into compliance, if not assess a fine of $250, administrative cost of $250, and a daily fine of $250.
I'll second. All in favor, please say aye.
Aye.
Aye. Any opposed? No. Motion passes 5-0.
Thank
The next case is 8.9 for the same address, and it's
Yeah, it's confusing.
yes, this violation, section 18.5.1, we asked for them to install a construction fence to secure the pool. Now, because we issued this violation separately, they have to be heard.
Yeah, it's
They-
fine.
They can have the same motion, however, we have to read it into the record.
Okay. Because there it just says we're doing construction without a permit. Weren't doing any construction, so.
No, we didn't say that. We said to put a construction fence to secure the pool.
Okay.
Right. On case number C.
It's the same.
No questions. On case number CN -23-60, I would request that be dismissed as.
A second.
All in favor, say aye.
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 All opposed? No. Motion passes 5-0.
Thank you.
I would like to put it on the record that we have posted back the safety hazard notifications to the public. That situation has to be resolved quickly because it is a safety hazard for the community. Okay. Thank you, David.
May I?
I'll move to the
Uh,
next.
Just for future reference, if there's any notification that needs to be sent to MPMR Holdings, would you be able to send it by email? If it's by writing, the address, I gave the address
Mhm.
before. If you don't have it, I'll be happy to give it to you again so that I can get the communications
Sure.
earlier.
Thank you for letting us know. We'll keep that on the record. However, I would like for you to understand that we are bound by law to send all violations to the address in the tax assessor's information. If you can fix that, we'll be happy to be sending you.
Are we gonna be able to carbon copy to the address?
We will send a copy to
Fine.
that address
Okay, that should help.
All right, thank you so much.
and follow up with a phone call like we did this time. Thank you. The next item is 8.11. This is for the address located at 10931 Northeast 10th Avenue, case number CEN 23-283 for Jeffrey Draymond. They are requesting a continuance. They have a permit in process for a driveway. The permit number is DWS-23-277. And is that your property, David?
No, so Dave Gruen, 11520 Griffin Boulevard. This is actually my neighbor across the street.
Oh.
My first house, my first love in Biscayne Park. He's a great guy, but he's 76, doesn't have an email address or any of that stuff. So the whole OpenGov portal submitting all that, I kind of took over everything for him. The one thing that I would say is the permit was actually approved on October 16th. The first GC, which I helped him engage with, everything was great. And they said, all right, cool, we'll do this next December, as in December of 2024. So we were like, all right, that's not going to work. The second one ghosted us, but we now have, after a month and a half, but as of the beginning of March, we finally basically got a guy that owns, what's the name of it? Sorry, I wrote it down real quickly. It is Francisco Concrete Services. I just wanted to be known, Jeffrey Draymond did pay like all of the fees and everything he was supposed to, and we were hoping to have it done before it got to this, but I anticipate that since we have the permits and everything like that, the construction will be done within 2 months, and it's a duplex, but he's the only person that's ever lived in either side. One side he just keeps empty and fills with his extra stuff.
But you're still waiting on the things that it shows us here that you're still waiting on? or-
Because our GC was changed twice, we were waiting for the GC to basically send back a estimated start date. because we didn't want to have the same problem as the
In
first.
going the way we've gone all night, we are trying to give an endpoint realistically. Since you were going through this, what realistically to you would be an endpoint that you're confident all those documents could be in?
No, so the notice that we got, or that he got, was March 6th, and by, I think it was like March 10th or so, they'd said, oh yeah, we'll start by the end of the month. And again, we already have everything approved and everything, so.
We recommend 90 days.
Okay, I mean, it's whatever you guys want to do, but in my understanding, it shouldn't take more than 2 weeks to cure, but.
But if
I'm
it
not
does,
GC.
then we have to deal with bringing you back again
That
on
was
a
fun.
month to month. Well, no, we get overwhelmed with the amount of work, so.
Yeah, and you guys are doing God's work, and it's the Planning and Zoning Committee trust that we get a lot of driveway permit applications as well, so. But yes, he was terrified when he got this notice, because he's been here since 1973, and he's never gotten code compliance violation. I was like, I'll go for you, don't worry about it.
Is there a motion?
Okay, why don't I make a motion that in CEN 23-283, we give them 90 days to comply, so that would be June 20th. And if not, then the $250 fine, $250 administration, and $250 per day fee would go into effect.
I'll second. All in favor, please say aye.
Aye.
Any opposed, no? Motion passes 5-0. David, thank you
Yep,
so much.
thank you guys very much.
Thank you, David.
You were sitting here for, but we really appreciate you being here. You gave us good info.
Very much.
Mhm. Thank you. It's this one now, right? Next case is item 8.15. The address is 11905 Northeast 12th Court. The case number is CEN 23340, Nicole Jean Jacks and Jean R. and Jean Jacks, I. Smith, Jean Jacks. We're asking for an order of enforcement. However, they have asked for a continuance. Do we have a letter?
And on what basis this is 8:15?
That's what I'm looking for right now.
Yeah, because
Yes.
they got a courtesy notice in April of 2022.
Right.
So we're talking 2 years.
Well, yeah, the courtesy notice gave them actually a pretty nice amount of time
Mhm.
given until January the 2nd of 2023.
Right.
So that's 8 months. Then, they didn't comply by August. There was no compliance of 2023. And then by March the 6th of 2024, there was no compliance.
I'm not inclined to a continuance. It's 2 years.
Okay. There is no permit in the system. I would like to put that on the record.
All right,
And
I'll make the motion that a violation did occur and that that we will put forth a $250 fine, a $250 administration fee, and a $250 a day fine. When do we pick a beginning date? Compliance date of.
May 1st?
Compliance date of May 1st.
April, what's the date?
May 1st.
May 1st.
I'll second. All in favor, please say aye.
Aye.
Any opposed, no? Motion passes 5-0.
We'll move to section 9 so we can take care of Mr. Londono over there.
Sorry, sir, I apologize. So long evening. Thank you for your patience.
This is in section 9 and it's item number 9.3. The address is 11659 Griffin Boulevard, case number EEN 21-0737 for for BP Apartments LLC in care of its registered agent, Mr. Londono Octavia. Mr. Octavia is here to ask for a fine reduction for this dumpster violation that has been going on for quite some time, since 2021. The staff is recommending, he has put in his own recommendation, but we are recommending $1,000 just because this case has gone on for a long time, and compliance just happened, I think, last month or a couple of months ago.
Any questions from the board yet? Sir, if you would identify yourself and your
Okay.
relationship to the property.
Yes, my name is Octavio Londano, and I am the owner of BP Apartments LLC. The reason why I suggested the reduction was because I got a dumpster to alleviate, and I think I explained this in the past. The dumpster was moved by code. They told me to move it to different sections. They never said I was in violation. Apparently, they issued a violation 2021. I never heard anything about it until just recently from Ms. Doreen Grant, what, about a year ago, maybe a little less? And I didn't know anything about a violation. Then what I ended up doing was getting rid of the dumpster, because if it was gonna be such an ordeal, just get rid of it. I got rid of it. And then the trash cans became also in violation because they cannot be seen from the road. So I thought the trash cans were different. So then the trash cans got taken care of. And while I had the dumpster, I was paying for collection fees for 5 units that I paid to the city taxes. I never went back and got that money. And I feel that if I'm going to be fined, then that is part of the retribution to the city for this ordeal. And that's why I propose, $100, because it does cost me about $4,500 to $5,000 a year in trash collections and my taxes for that property.
Questions from the board?
Well, whether you use our trash or use your own trash, the city has to pay. There's no retribution to the city. We have to pay Great Waste for the collection for each unit. So we don't get money back out of them if you're putting in a dumpster. We still owe them the money. So there's no retribution to the city, and there's nothing for the city out of it. We are paying, and that's why when I first came into the city, there were people who didn't pay their garbage bills. Then it was put on to, thank God for Richard Eater and the crew. It was put onto our tax bills because those of us who paid were paying for others, but the city still has to pay no matter what. So there's no retribution to the city.
So all the multifamilies, they have their own dumpsters. They're paying collection to the city as well as the dumpsters?
You're paying collection to the city.
The city pays Great Waste.
And the city pays Great Waste, correct? Everybody. There's no out of that because we contract for the entire village, and there's no way to nickel and dime down a little here and a little there because we're a very small village, so we don't get a whole lot of people wanting to pick up our trash.
Okay.
So I guess what's before us is an offer of $100 against an outstanding fine of, I believe it was
$46,000.
$46,000 plus. I'd like to make a motion to deny the offer of $100.
I'll second.
Like,
Yeah. All in favor, please say aye.
Aye.
Any opposed, no?
like to make a
Motion
different offer,
passes,
sir.
motion passes 5-0.
In
Or
lieu,
what the village had recommended.
The village is recommending 1,000 to cover the years of administrative work and follow through that went into the case.
And we also considered that this is not a homestead, this is an income producing property
It's a business.
for Mr. Londono. It's a business, so we took that into consideration.
I do recognize that he has been making some effort.
He has.
Yes, and, finally, the dump truck stopped crossing the median. which was another expense to the village.
That's correct.
That.
And
I forced him to come here,
and Doreen,
and he did.
Doreen, your recommendation was based upon calculation of the time and effort and the hours that you all had put in.
That's correct. This violation was opened in 2021, way before we all came here. But Mr. Londono is right that there was some confusion again in the communication. However, when I found this violation sitting there, I contacted him and we started working together.
So at this point, your offer has been denied, or we adjourn for the evening. Would you like to make a different offer, or?
500? We split the difference. I mean,
Personally, I will not go anything lower than what has been recommended by the village. They're in the best position to know what went into dealing with this case for almost 3 years, so.
okay, I'm willing to accept the village's recommendation of $1,000.
You'll accept 1,000, sir?
Yes.
Okay.
In that case, on case number EEN-21-0737, they can make a motion to accept the property owner's offer of $1,000 to be payable within 30 days. What is this? April the 20th.
I'll second.
All in favor, say aye.
Aye.
Any opposed, no. Motion passes 5-0.
Thank you, Octavia. I'll send the order in the mail.
Have a great evening.
What date for payment, Dale? Thanks. No.
Michael.
Michael.
5-0. That concludes the fine reduction, so we'll go back to no business. What there? 8.16, 816. The address is 11921-23 Northeast 12th Avenue, and 23-339. This is for Arlette Romaine and Jean Pierre. Violation is for a driveway. There is no permit in the system. And I don't believe we've spoken, we haven't communicated. I called Arlette, I found her number, but I didn't get a call back.
If everybody would please look at the return receipt requested mail. I think we're gonna have to hold this off till next month to have them re-noticed. Notice the address,
Let me see those yours.
2nd Avenue.
The second, oh, I'll look at it.
If the property owner was here, it would be one thing, but with the property owner not here.
Yeah, that's not in Biscayne Park.
Yeah.
Go ahead and make a motion, Jamie?
Yeah. I would make a motion that we table this until next month's meeting to have the owner properly noticed.
I'll second.
All in favor, aye?
Aye.
Any opposed, no. Motion passes 5-0.
Let's see it.
What? Again, if the owner was here, it would be one thing, but they're not.
Glad you saw that, because that got right by me.
I'm sorry, who said, Dale, you second?
Yes.
Thanks, Doreen.
817.
So we're moving on to 817. Thank you for that, Madam Chair. We're moving to 8.17. The case number is 11947 Northeast 12th Court, case number CEN-23-332. It's for Marcel and Augustine Perry and Kenny Jeffrey Perry. We are asking for a finding of fact, an order of enforcement. Evidence was provided by a previous tenant. I believe we have entered that onto the record. We issued them a violation for renting the unit on a long-term basis without first obtaining a permit.
Yes, and I also noticed this property is homesteaded. I know it's a duplex. I don't know if the property owner lives on the other side, but if not, I don't know who would look into that. But I see the resident had provided a lease. I mean, the renter had provided a lease and everything else. Had the property owner been in communication with the village as to this notice of violation?
I'm sorry, I didn't hear that part.
I was just saying, has the property owner been in contact with the village as to the violation?
Where's Luciano? Oh, yes, we spoke with the officer spoke with the property owner. He actually contested this, and I was hoping that he would be here tonight. However, we had overwhelming evidence to show that he was renting this property, and
Notice which the ordinance requires.
he absolutely did. We had other violations on the property which are now in compliance.
Well, given that, I'd like to make a motion on case number CEN 23-332 that a violation has occurred. Assess a fine of $250, administrative costs of $250, and comply by April the 10th, or a $250 per day fine thereafter.
I'll second. All in favor? Aye.
Aye.
Any opposed? No. Motion passes 5-0.
That's the last case.
That's it.
No,
I be-
you have the minutes?
The minutes we,
Oh, the minutes. There were two things I found in the minutes.
bear with me, let me get organized.
7.14.
7.4 or 7.1?
7.14. 7:14. In my paperwork, I had it listed as Janie making the motion and Judy second. Am I wrong?
7.14.
I don't know. I could have it wrong.
7.14 I
Bear
have.
with me.
Was that, I had a motion. Right, this is for the February minutes, right?
Right, when,
I had on 7.14, motion to dismiss was Michael and Rodolfo, and it failed.
that's
And
correct,
then-
we have that.
And then it was Dale and Janie.
Okay,
That's what we have.
Yeah.
okay. Then I was wrong. That's okay. That's fine.
That was a long one. What page is I have?
And on 7.20, I had it as 4-1.
7.20.
I have it as 4-1 also. Yep, you're right. Good catch, Judy.
I have it as
7.20, 12010 Northeast 11th Place. I have it as 4-1.
4-1. Do we know who opposed? Or who
No.
was the no?
I usually write that.
I didn't write it either, but 4-1.
Okay, we'll listen to the tape again.
But, I have 4-1. The case was tabled. The motion was seconded. Oh, we don't,
I
Yeah.
had Janie and Dale. and
Right.
I have tabled for March meeting.
right. But I have it 4-1, and you know what? I
Well,
don't
you
know
have
who
March,
opposed.
And I have March, I don't
Right.
have an April. Where did 4-1 come?
Right.
4-1 is those who, not till April, that's 4-1 against.
Right.
That's-
Oh, yeah, no, 4-1.
So someone was against tabling this case?
Says she has 5-0.
Oh.
And
Yeah,
So someone was against tabling this case? Is that what you're saying?
that's what I have.
Okay.
do we remember who was against?
No,
No, see, I don't even.
Doesn't
but
sound.
I marked that it was 4-1 against.
We'll check it.
Oh, thank
We'll listen to the tape again to make sure.
Semantics,
Mhm.
sorry.
No. Okay, the big one, and I have lost. Okay, I'm sorry, Judy, were you done? Okay, on 7.5,
7.5.
what's missing is the $250 admin fine should go in there also. Now, on case 7.7, can I borrow somebody's 9.2 for tonight? I've moved my 9.2 around so often I can't find it because 7.7, it would be,
Before we move, I'm sorry to interrupt you. On 7.5, what do the others have? Do you have a 250 administrative fine? Because we didn't have that.
Yes, I have violation, 250 fine, 250 admin
Right.
by 3, 4, or $250 per day.
So we have 253 times. Okay,
Dale and Janie.
The three timers, yes.
okay, thank you.
Can I borrow your 9.2 from tonight?
I have 250, 250, 250.
Thank you. 9 point,
Somehow I managed to lose 9.2 because 9.2 ties into 7.7. Thank you. Not, on 7.7, it says if a permit has not been pulled by March 6th and fine paid, it talks about an additional daily fine. Well, there's already a daily fine on that,
is that 7.7?
7.7,
Okay,
where it says
Oh, right, question paid by.
it has another
Yes.
daily fine in there. So what I was thinking, if you look at 9.2 from tonight, 9.2 on the order of enforcement, that paragraph under the order of the Code Compliance Board is as follows. The paragraph in that would actually make for a good and proper addition to 7.7 after the motion and all of that. if
you're
you-
right. Dale did add a 250 administrative fine. So when we add it to the,
Yeah, you
it
went with the
becomes
daily. right.
750, because you deducted.
I added that back in too.
You
Right.
did?
Yeah.
I'm
Get
sorry.
the 23,500 or is it 23,750? After you add the two,
I'm up today.
right?
We had two, the first one, we just reassessed it or whatever. and then
Right.
I added the next. group.
Then you added, so we had
It would have been a $500 administrative
fine,
fee
fee,
total.
50 fine,
Yeah.
so that's 750 plus the daily. So 23,750 was right. In the agenda.
Which one are we on, 7.5 or
So-
7.7?
We are on 7.7 and you referenced the fine reduction 9.2. That's the same property. But Adele had corrected us in saying it was 23,500 and not.
Oh, yes, yes,
23,750.
yes. Right.
However, if 500 was assessed as the violation, the fee, plus 250 violation fine, that's 750.
Right.
It's all right here. It should be 23,500 because you started the day earlier. It
Mhm.
should have started December the 1st. So if you remove 250, everything else adds up to 23,500 and not 23,750.
750. Yeah. So I
Because it
may-
has the
I
three-
added
it
that
has the-
250 without realizing that it started on December 1st. You're right.
Right.
But going back to the minutes talk about an additional daily fine, which you can't have because you already have a daily. And I was just saying that on 9.2 from tonight, if you look at the order of enforcement, the area in red of our findings actually would cover
That's correct.
the minutes,
Mhm.
except obviously for who made the motion and the vote, et cetera, but
I see
Yeah,
that. Mhm.
would fit perfectly.
It's already on order of enforcement.
I think that's all I found in the minutes. Does anybody else have? You know, I do too. Is everybody okay with that if we move the minutes to last on the agenda? Judy, I totally agree. Yeah. They don't need our housekeeping. They don't need our housekeeping. You're right. Okay.
Anything else?
We tabled the discussion for the code compliance department and standing operating procedure.
So on that one, I have to apologize to the board that I brought this to the board. The village attorneys, reviewed the document, and when they found out that I had asked the board to make recommendations, they clarified for me that the board of a quasi judicial body cannot participate in an administrative procedure in making policies for.
We didn't vote on them.
Michael, I saw that.
We didn't vote on the minutes, you guys.
Oh, the minutes.
I would make a motion to accept February's minutes with changes.
I'll second.
All in favor?
Aye.
Aye.
Motion passes 5-0. Good. I'm sorry, Doreen. My apologies.
No, you're good. So I was saying about the policies and procedures that Attorney Valerie Vicente reviewed the policies, and in the end, she advised that this is a quasi judicial body and they cannot participate in reviewing administrative policies. So, so unfortunately, while I personally was looking for those recommendations, legally, I cannot take recommendations from this body. I apologize for that.
I just want to say one thing, 'cause I don't want to forget to say it in April. I won't be at May's meeting, and normally if I'm not gone a long time, I ask you guys if you don't mind changing.
Okay.
I'm gonna be gone too long to ask you to change May's meeting, and I just don't want to forget to tell you I will not be at May's meeting.
Okay.
Yeah, well, I may not be, because I'm next week, but I don't know when I'm going yet, so I can't say
Okay.
anything.
Okay, are you gonna let us know so we arrange to either postpone or change the dates for the May meeting? Yeah, we'll wait for you.
Okay, anything else from anyone? Motion to adjourn?
Second.
Quick question, how was the electronic agenda for Michael, OneDrive?
I gotta say that I wasn't able to download it this time, but not because the minute was sent, it's just that I just didn't have the opportunity to do it.
Okay.
But can you please try it again, because I do want to try it next time. I'm sorry.
No, it's fine. We'll continue to send the electronic, but I believe we